Writ petition is allowed. Respondents are directed to reconsider the case of the petitioner in accordance with the guidelines, particularly clause B, and if one of the documents required is submitted without insistence on the year of documents for allotment of the room, shops at Cruise Market and Common.
May I please your lordship? My lord, I beg to mention item 53, my lord.
53.
My lord, in this matter, I have filed a small affidavit, my lord, today, my lord. That may be called to record, very urgent matter, otherwise. 53, my lord, 53.
53.
Yes.
53 is for what?
My lord, what else, my lord, the regarding promotion, my lord, promotion is given, my lord. Everything is after the interim order. Only small thing remain, my lord. Today, your motion may dispose of it. It will take 2 minutes only. And I have filed an affidavit in this regard, my lord. Small affidavit, the subsequent development.
How do we dispose of the orders today?
My lord, subsequent matters, my lord, already taken place, my lord. Just to maybe your lordship, my lord, it will be over.
53.
53. Yes.
May it please so much.
Yes.
Well, item number 62.
62.
We had actually prayed for the matter to, it's a bio matter. We had listed at the matter.
62. Ah,
My lordships, presently we need to file an additional affidavit to bring some information.
why this has been on?
Initially, it was for admission,
Hmm.
so the matter could be expedited, But yesterday I got a call that some affidavit needs to be filed. In these circumstances, I sought the consent of my learned senior colleague, Could it be after a week or so?
After 3 weeks.
Very well.
On the prayer of Mr. S. Banik, learned counsel for the petitioner, list this matter after 3 weeks so as to enable him to file additional affidavit.
Obliged.
May I please, Lordship?
Yes.
Lordship, item number 10, Lord. So we are withdrawing this matter, Lord. Have the
Okay.
instructions to withdraw this matter?
Mr. A. Kolita, learned counsel for the petitioner, submits that he has an instruction to withdraw this petition. Mr.
My lord, I am appealing
Obliged,
to the respondent.
My
lord,
is
signed
present.
permission.
Is present. Learned counsel for respondent is present. According to the petition stands closed and dispose the bond withdrawal.
My lord's kind permission, may I mention a matter which was listed on 18, 3 days back. I was pressing for a status quo. The state sought an adjournment on that day. My lord, this is regarding teachers' recruitment. I was connected virtually on that day, my lord. 2 hours later, they have issued a list to start verification from yesterday. About 300 students have been verified.
Monday.
My lord, there is some urgency. If I can
Monday,
pray for 2 o'clock.
Monday.
My lord, can I just take a minute? I'll just take a minute, not more than that. Because there are 4,100 verifications that need to happen. 300.
Just check it. It's 1 minute or 2 minutes. Yes. Proceed.
Just 60 seconds actually. 300 students have already been verified yesterday. 300 more will be done today. For the same very 4,100, I am also claiming my right on the basis of an Honorable Supreme Court's order 4 months back. All states have implemented. It is only this state of Assam, which is not implementing. Today, if another 300 are verified, Manoj, I will have to deal with 300 more till Monday. And for Monday also, there are 300 more. So every day, Manoj, 300 more verification of documents will take place. I am only on this application. I am not on the final hearing. This verification, because the state took time, and 2 hours later, Manoj, after the hearing, they issued the notice saying that next day we'll start verification. So Manoj, more third-party rights would be created and completely in violation of Honorable Supreme Court's order. Completely. Only the IA, Manoj, not more than 2 minutes in the IA I will take. In fact, I won't even argue the IA. I've explained my.
What do you want? What order you can pass?
Manoj, stay the very well. Manoj, the reason is this, Manoj, that there is already 2 status quo stay orders granted by this court. For the same very posts where we have not been included, they have started the verification process. Now, if the verification process for those students start, then where will we be, Manoj? And we have been fighting this case way back from the first month of 2024. 1 year we have been fighting. 10th December 24, the Honorable Supreme Court clarifies and makes it applicable from a back date. the advertisement for this very post is after the Honorable Supreme Court's order. So therefore, my lords, all that is happening today is in direct contempt of the Honorable Supreme Court's order. All that I am today saying that kindly stay this process for one reason, that whenever the matter is comes up, it shouldn't become infructuous. And specifically when the state sought an adjournment the last time, saying that they will not do anything, there was an oral submission made from the state side. They said they will not proceed with anything. But 2 hours later, I will show from the documents, they released the list and to start the next very day. So when 41, those posts, I'm sorry, I've exceeded 60 seconds, but those posts 4100 for which we are also claiming right, for which the Honorable Supreme Court in 8 states. Sorry.
At 2, we'll take it.
I'm so grateful.
My lord, there are 2 IAs we have filed, my lord. My lord, there are 2 IAs we have filed on similar ground, my lord.
Identical.
My lord.
I'm so grateful, Manoj, and I'm sorry.
Obliged.
May I please, sir?
Inform the other side.
Yes, my lord.
You are there?
We've informed you.
Yes, my lord. For the state of Assam and for the NCT, we inform you.
You inform them.
We have informed them already.
May I please? Sir? Item 19 and 20, Your Lordship.
Yes,
Maybe pass forward for some days, Your Lordship.
19 and 20.
19 and 20.
What's the matter?
It is regarding the appointment of Gaubura.
Huh?
Regarding appointment of Gaubura.
So,
So I need time because I need accommodation today.
why?
Because I am leaving this court at
Why
11.
you are after the appointment of Gabura?
They have conducted an interview. The result has not been declared.
Okay.
Because of that, I have filed it.
You will direct them to declare the result.
But after 11, I cannot stay here.
Why?
I have some work because
Only
if it is
prayer of
possible,
Mr.
and
And then
then
over there, learned counsel for the petitioners. List this matter after 6 weeks.
2 weeks, Your Lordship.
Hmm?
2 weeks, Your
3 weeks.
2 weeks, Your Lordship.
3 weeks. We want to dispose of the matter today. You are seeking time. 3 weeks.
And then Your Lordship upgrades the matter.
No. There is no urgency.
2 weeks, Your Lordship.
Okay, 2 weeks.
May it please, my lord.
Yes,
My lord, with the consent of the other side, I seek adjournment in 44. I have got a respondent 3 and
44.
I have taken a consent of my colleague, my
Yes.
colleague from the petitioner side.
You are for respondent.
3 and 4.
Mr. So-and-so, learned counsel
May I please?
for the respondent 3 and 4.
I am for a petitioner, my lord. Kindly a date name.
This, learned counsel for the petitioner. Respondent number 3 and 4.
Yes.
And as agreed to by, as consented by the learned counsel for the petitioner, list this matter after.
In the first week of April, my lord, can be.
Huh?
In the first week of April.
After 2 weeks.
Obliged, your honor.
May I please, your lordship? Lordship, I beg to mention item number 3 of today's list, lordship. Lordship, the conducting council, Mr. A. Suma is out of station, lordship. Can it be taken up?
On the ground that Mr. A. Chamua, learned
That's it.
counsel for the petitioner is out of station, MS so-and-so. Press for adjournment of the matter. Please, prayer is allowed, list after 4 weeks.
Wait, Mr. Lordship. Lordship, I beg to mention item number 22 and 23. The matters have come up under admission, but they're already admitted. So
Yes,
they may be fixed for hearing, my lord, after the few vacations.
you are,
Regarding, my lord, a departmental proceeding where penalty have been already imposed.
Hmm.
Can it be, my lord, for hearing on 29th of April, ma'am? Immediately on the
29th.
new pending, ma'am.
okay. As agreed to by the learned counsel for the petitioner, Mr.
DK Bhattacharya.
D.K. Bhattacharya and Mr. B. Gover,
My lord.
standing counsel,
Yeah, my lord, Health Department,
health department. List this matter
29th.
on 29/04/2025.
Obliged.
Item
for
28. Item 28, my lord, I am appearing for the final department.
Hmm.
Our instructions are awaited. Can it be after 2 weeks, my lord?
Yes, on the prayer of Mr.
I have taken the consent, ma'am, for finance, ma'am.
B. Gover, learned counsel, learned standing counsel finance. List this matter after 4 weeks.
Ma'am.
Weeks.
Huh?
2 weeks.
May I- May I?
Then 2 weeks to obtain instruction. Huh?
May I
Yes.
please, the lordship, I beg to mention item number 27.
Yes,
Concern of the other side, lordship. MSG Borgoha is out of station for her medical treatments.
on the ground of Mr. MS D. MS, on the ground of MS D. Borgoy, Learned Counsel, the outing petition for medical treatment. MS for Learned Counsel. Request for adjournment in fair is allowed this for 4 weeks.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 1, lordship.
My lord, I am for the petitioner, my lord.
Yes.
The matter may not be passed over today, my lord,
Right.
because the 2019 matter and the petitioner before lordship
What
is
the
financially
matter?
suffering, my lord. My lord,
What is the matter?
my lord, matter is regarding family pension.
Okay.
Family pension, the petitioner before lordship have no child and is an unemployed person, my lord. And on the other hand, the private
The
respondent
dispute
number 5,
between two wives.
two wives.
Lordship, yes, lordship.
Two wives, but she is divorced, my lord, as per the degree of the
Lordship,
civil code, my lord.
family
And my
court
lord,
matter is going on
they
also
have
regarding.
filed an affidavit, my lord, on behalf of respondent number 5. The pleadings are complete. The petition is to be disposed of, my lord, only. So,
50-50.
my lord,
50-50.
50-50, my lord.
No, 50-50. Share 50-50.
Lordship,
Family pension.
lordship.
You share the family pension
My lord.
50-50.
My lord, the respondent number 5 is the
Heard Mr. So-and-so.
no, no,
Learned counsel
my lord,
for
this
the
is the
petitioner
different case.
and Mr.
I am for
So-and-so.
respondent number 5.
My lord,
Learned counsel for the
my lord,
respondent and Mr.
I am for respondent 5.
my lord, disposing of, my lord. My lord, disposing, my
So-and-so.
lord. Not 50-50, my lord. She is a divorcee, my lord.
Considering that the dispute relates to two wives of late, what is the name of your husband?
Ridip Mohanto.
Ridip
Mohanto.
Mohanto.
Ridip Kumar Mohanto.
Late.
Late.
Considering that the dispute disputes relates to claim of family pension between the two wives of late Ridip Mohanto, the parties are granted 3 weeks time to make an effort to settle the matter.
Lordship.
Settle
No,
between
Matter is not like that, man.
Matter is not
His
like.
first wife already divorced by the decree of divorce, man. She has gone, man. After decree of divorce, man, the second wife has been married, man. They
Okay.
don't because of this, man, the first wife for the family pension, man.
Okay.
That is why, man. That is a catch of the matter. Lordship may fix a date, man, for hearing, man.
Lordship, a date may be fixed, lordship, for them.
Otherwise, I am ready, man, because he has told me yesterday night, man.
Delete that, heard so-and-so. As agreed to by the Learned Counsel for the parties, list this matter for the writ petition is admitted for hearing.
At the admission stage, man.
At the administration.
Then, as agreed to the Learned Counsel for the parties, list this matter for admission after 3 weeks.
Lordship,
A date may be fixed, man. A date may be fixed. Any date.
3 weeks, give the date.
My lord.
lordship, much obliged.
May I please, your lordship? My lord, I wish to mention item number 55, my lord. In this-
55.
Lordship, in this case, the conducting council, Mr. Selim is out of station and respondent number 9,
55 is for orders. We'll see what order has to be passed.
respondent on last hours and respondent took time for filing affidavit in opposition. That was not filed till date, my lord. And
On the
the
prayer of Mr. You are for petitioner.
petitioner, H. Ahmed on behalf of M. Selim.
So-and-so. Appearing on behalf of Mr. M. Salim, list this matter after 3 weeks. In the meantime, respondent may file their affidavit.
Lordship, I beg to mention item number 41. Better be adjourned for the day.
41.
41.
You are for?
I'm for the petitioner.
Amen.
A.K. Kanu.
Mr. A.K. Kanu, Learned Counsel for the petitioner, submits that press for adjournment of the matter. Mr. Fair is allowed just after 4 weeks.
May
Just
please, Lordship,
after.
in regard to item number 2, my lord, the petitioner will be filing her reply against the respondent affidavit. My lord, I pray for 1 week time. We have sent it for vetting.
Reply.
My lord, they have filed additional affidavit,
Address so-and-so. Learned Counsel for the petitioner.
my lord.
Praise that she may be allowed, she may be granted further 2 weeks time to file affidavit in the claim. This prayer is allowed. This after 2 weeks.
May I please, Your Lordship? My lord, I beg to mention item number 39. So in this case, my lord, I have filed an IM, my lord, but that has not been taken in the record. The record may kindly be called for. 39.
Mr. Ali,
A Ali,
Ali, Land Council for the submits that he has filed it
IM.
for what?
IM for, my lord, because
He has filed an interlocutory application on when? When did you file?
my lord, it was filed
Submits that he has filed an interlocutory application, however, some is not listed in the, he is not listed along with the petition. Mr. Considering,
no, my lord, I am not seeking adjournment.
considering above, registry to verify. And if IA is paid, list along with this, list along with the requisition 305 2020. After 2 weeks.
No, my lord, in that I have some urgency, my lord, because the state respondents has, my lord, given the source of insert receiver to the private respondent number 5, my lord. And that, with regard to that, I have challenged that, my lord, in this case, and subsequently I have
After
challenged
1 week. We'll take
I
it
will-
up after 1 week.
on next, my lord, on the next witness day, my lord.
After 1 week, in charge principal, nothing,
My lord.
no urgency.
Obliged.
May I please your lordship? Lordship, I would like to mention item number 9. Lordship, the engaged counsel M. Ahmed has some serious medical emergency.
On the ground of Mr. M. Ahmed Land, counsel for the petition is under medical emergency. Mr. So-and-so.
Mr. M. Ahmed.
For adjournment of the considering about.
The lordship,
Considering that.
1 week time may be given.
Considering that Mr. Ahmed then counsel is in, and is under medical emergency, let this matter be listed after 3 weeks. 3 weeks.
3 weeks.
Yes. And for respondent number 11. Who are you? I'm the high school lordship. Actually, the amalgamation order notification OM 28. So he wants that it should not be amalgamated.
Yes.
Huh?
Yes.
Amalgamate. Should not be amalgamated. Huh?
Petitioner has challenged the amalgamation.
Yeah. Why? On what basis? There is a violation of notification.
Otherwise, also lordship matter pertains to BTC.
Within same campus school lordship.
No, according to them, if it is less than 15 numbers of students, then only amalgamation is permitted. But in their case, in their school, it's more than 107 students. How do you justify? How do you justify the amalgamation, Mr. Sharma?
Lordship. Same campus.
The requirement is that if a school consists of less than 15 students,
But it appears that both the schools remain situated in the same campus. In that situation, lordship.
no,
otherwise-
whether same campus, not same campus. If it's a separate school, you have the notification, you have to adhere to that. Anyway, non-appears
Non-appears.
petitioners on call. Mr. Swenso, P.N. Sharma, London Standing Council, Elementary.
Lordship, I am for only respondent number 1, lordship, otherwise 1 and 2. 1, 2, and 3.
And Mr. Swenso, London Council at present. List after 4 weeks.
That may be the news has only started from.
Is there any stay order operating? Is there any stay of
Yes,
the
yes,
amalgamation?
there.
Huh?
Stage there. That is why they have. Since last 4 years.
2 weeks, in that case, 2 weeks.
This matter perhaps has become, my lord, infectious because of the order passed by a division bench of this honorable court. Here the petitioner is praying for his promotion from the post of LDA to the post of UDA. The fact is, my lord, the substantive post of the petitioner, he was initially appointed as a, my lord, surveillance worker. There is a complete separate cadre. They were, my lord, posted on, my lord, deputation in, my lord, under the Director of Health Services as a LDA. Now, my lord, when all these things, there are other persons also, my lord, when all these things came to the knowledge of the government, all were reverted back to the original post of surveillance worker. Challenging that reversion, they approached the honorable court. Single bench, my lord, dismissed. Now, division bench has also dismissed, my lord, appeal order of the non-executive justice.
Similar order. In similar order.
No, say this petitioner, my lord. While, my lord, after his reversion to the, my lord, post of junior LDA or the junior assistant, he is praying for his promotion to the upper division assistant. But, my lord, since he is a surveillance worker, he has been reverted back to his original post of surveillance worker. From surveillance worker, there is no promotional avenues to the post of UDA. So,
Challenge here is what?
Lordship will see the prayer, my lord.
Or directions will be issued by respondents to the interim order passed issued by joint director of so.
Prayer starts at page 16.
Requires the next year to do Departmental.
Lordship will see in the second page, the writ appeal number 125 of 21, in the second page. That is the, my lord, writ appeal of the writ petition. Raja Sharma. Then the issue was, my lord, Lordship will find it.
Appeal number?
Here the petitioner's name is, my lord, Raja Sharma. Same person, my lord.
Raja Sharma, huh?
Yes. Now, Lordship may kindly turn to internal page number 9. Or page number 8, my lord. Yes, page number 8. Para 3, my lord. The brief facts of the case are that the appellants, writ petitioners were appointed as surveillance workers under a particular scheme, National Vector-Borne Disease Control Program, on different dates running from the year 1995 to 2009. Subsequently, on their request, the appellants or writ petitioners were posted as storekeeper LDA in the same pay scale of surveillance worker and BHW at various places on different dates. The state respondents by order dated has ordered for reversion of the appellant to the post of
Yes,
surveillance.
challenging the reversion.
In that manner, this petition, the challenge was to the reversion order.
This reversion. What is this 03/11/2018?
My lord, 3011.
Yes.
2016.
In this writ petition. No, 0003.
My lord.
11/2018.
My lord. Whereby, my lord, his promotion was rejected, my lord.
There is ordered for reversion of the appellant's request to the post of initially appointed. Agreed by the reversion, huh? Then
My lord, page number 58 of the writ petition. It says, my lord, with reference to the subject and letter cited above, we were hereby informed that the promotion from the post of LDA to UDA now cannot be done because of your case under judicial procedure WPC so and so. Because of the pendency of the earlier writ petition whereby the reversion order was put to challenge, the promotion was not considered.
7879.
Yes.
This was dismissed by single bench.
My lord,
Huh?
yes, my lord.
Where do you get it?
That number has not been reflected in the order, but my lord, the writ appeal is there. No, even otherwise also, my lord, they are different cadres, my lord.
Where the petitioner? Will it be
Probably.
closely matter?
Then lordship will, my lord, post it after 2 weeks, my lord, let it come. Because, my lord, otherwise it has become infrastructure, probably for that reason, my lord, it is not closed. Because they have been reverted back to their original post.
So challenge the reversion.
In the earlier batch, my lord, they have challenged the reversion.
Okay, we'll close it. Close it.
It can be closed otherwise.
None appears for the petitioner on call.
As none appears, it can be closed.
Heard Mr. B.B. Gogoi, learned standing counsel.
My lord, Health Department.
Health Department. Sister. The challenge in this writ petition is to the letter dated 03/11/2018, whereby the grievance of the petitioner for promotion from the post of LDA to UDA has been rejected on the ground that the matter is sub judice before the court being WPC 7879 of 2016. Please stop. It appears that the petitioner who was initially appointed as
My lord, surveillance worker.
surveillance worker
Within
Was
bracket, my
taken-
lord, BHW, basic health worker.
within bracket BHW
My lord.
bracket clause in the health department,
Under the health, director of health services.
in the director of health services, government of Assam. Thereafter, he was sent on deputation as LDA.
My lord.
LDA. Please stop. The petitioner and some other similarly situated persons were reverted back to the
Instead of deputation, lordship will say that my lord, on his request, he was posted as LDA. It is
not
there in the,
deputation.
not deputation. On his request, he was posted as LDA.
Then,
It is there in the appellate order.
was posted on the request of the petitioner
My lord.
as LDA. Where? Same department.
Same department, but my lord, they were initially under a particular scheme, National Vector-Borne Disease
LDA.
Control Program.
Please stop. The respondent authorities, the department, the authorities have reverted back the petitioner and other similarly situated persons to the original post of what surveillance?
Surveillance worker slash
Surveillance.
BHW.
Surveillance worker.
BHW, basic health worker.
BHW. Mr. The said reversion order dated, what is this?
My lord, there are 3 orders. In case of the petitioner, my lord,
30/11/2016. In case of petitioner?
that order specifically.
No, it's okay. What is it? That's not order. Reverted back to. No, what is it? It's with the. Against which? The writ petitioner and the other similarly situated person have approached this court by filing writ petition being WPC 7879 of 2016.
Yes,
Right.
madam. Yes, madam.
Mr. The said writ petition was dismissed by the was dismissed by the legislative judge, by this court. Mr. The dismissal order was taken to appeal. Mr. Not dismissal, Mr. Agreed by the dismissal of the petition. The petitioner has filed an appeal being WA
WA 125 of 21
125 of 2021.
in the second page, madam. Radha Sharma.
The division bench by an order dated
3524.
03/05/2024 in the batch of writ appeals, including the writ appeal number 125 of 2025 filed by the petitioner, has dismissed the writ appeals. Next paragraph. Considering that the grievance raised in this present proceedings for a consideration for promotion to the post of UDA in view of the pendency of the writ petition number 7879 of 2016 filed by petitioner challenging the impugn letter dated 03/11/2018, rejecting the claim of the petitioner as the matter was sub judice, I find that the writ petition has become infructuous. As the writ petition filed by the petitioner being WPC 7879 2016 has been dismissed, as well as the appeal, writ appeal 125 of 2021 filed by the petitioner have been dismissed by the learned single by this court, as well as the division bench. No, has been dismissed, huh? In view of above, the writ petition is dismissed as infructuous.
Well, obviously.
Yes.
Item 6, my lord, is they filed their affidavit in opposition. The petitioner, my lord, was appointed pursuant to orders of this honorable court as a constable, general duty in the CRPF. There was a 2 years delay in his appointment, due to which he has lost his seniority with his batchmates. He has been placed around 3 years after his batch had been appointed. He is seeking his seniority and the notional benefit equivalent to what his batchmates are drawing now, at least above what his juniors ought to have drawn. Well, they filed their affidavit. Lordship, it's ready for hearing. I can. The Lordship would find the advertisement under which he had applied. Is that page?
Who is for the respondent?
The Central Government Council, Mr. S.S. Roy was required to apply. He filed the affidavit.
What is their stand?
They say that Rule 82 of the CRPF rules say seniority shall be counted from the date of appointment.
Obviously.
Now, madam, that appointment has to be
Your appointment on the pursuant to the direction.
Orders of this court, my lord. So therefore,
what was there in the direction? Let us see.
My lord?
6 to
6 to 9.
No, it's not now.
Yeah, Lordship, the concerned council, so he's out of station, Lordship. And although we have five here. Direction of this course.
Of this court, my lord, lordship find the directions at page number 24 onwards, my lord. The relevant portion, lordship would find it page 22, the type copy. Second paragraph from below, my lord, if I did. In the above circumstances, more particularly when the advertised, page 22, my lord. That is the type copy. In the above circumstances, and more particularly when the advertisement itself provided for 23 vacancies of constable driver and categorization of 12 and 6 vacancies respectively in the above categories, general and OBC, I am of the considered opinion that the particular plea of the reduction of posts due to remastering is not acceptable. If any such reduction was there after the advertisement or selection process, the respondents could have justified the same by producing the records and meeting the queries made in the aforesaid order dated 10/5/10. Instead of trying to substantiate their claim by filing the additional affidavit without meeting the points raised in the order dated 10/5/10. In view of the above, both the writ petitions are allowed, directing the respondents to take further process towards appointment of the petitioners in terms of the advertisement and the vacancies notified therein. That is 12 general and 6 OBC. Let the entire exercise be carried out as expeditiously possible, preferably within 1 from today. So my appointment was against the vacancies of that particular advertisement itself. Further process towards appointment of the petitioners in terms of the advertisement and vacancies notified therein. What they had done was, madam, having advertised 23
It doesn't clearly say that it should be from the date of the appointment.
But madam, if the appointment is in the vacancies advertised, there are judgments of this honorable court and even the Delhi High Court are there, which says that the delay in the appointment will not take away my notional seniority. Judgments of this honorable court, one division bench judgment is there, one single judgment is also there.
Yes.
If I can refer to them.
Lordship may fix the matter next week, Lordship, because the concerned council is out of station. And in fact, Lordship, they file affidavit in view of rule 82. Otherwise, I am not going to submit. Let's make it. Rule is always there. Yes. Next week, Lordship.
That rule, similar rule has been interpreted by this honorable.
But prime facie, I am not pursuing.
Try my luck with the judgments that are before me.
Admit that. I assume that let me consent for the petitioner. Mr. Next para. A Decalogy on behalf of SS Royal Council submits that Mr. SS Roy, learned CGC. Yes. Is out of the station for which he prays that the matter may be adjourned for 2 weeks. Anything? Prayer not being objected to by the council for the petition come out. Then this matter be listed after 2 weeks.
Lordship, here in this case, Lordship, I seek some times, Lordship, for instruction, Lordship, and pedagogical comment, Lordship. And
What is the matter?
Lordship, the petitioner is seeking seniority and graduation because, Lordship, he was initially selected in the year 2006.
Yes.
But because of some illegalities, Lordship, his appointment was delayed before the Honorable Court interfered, Lordship. And in this Honorable Court's order, Lordship, there is already a Lordship observation. Lordship may kindly see at page 16. Keeping in mind the above position of the case, it is hereby provided that the appointments of both the petitioners, although have been effected on 11/1/2012 and 26/7/2012, but the same would relate back to February 2006. That is the date on which Sri Gugul Sharma was appointed. However, they will not be entitled to any back wages except continuity in service for all other purposes, including notional fixation of pay. So I should be given seniority and gradation from when the last appointment was made in 2006.
Yes.
Lordship,
It's very clear.
Kindly fix the matter, Lordship. After 2 weeks, Lordship, I will submit my affidavit, Lordship.
Affidavit.
Yes.
Lordship, one more clear cut. You read page 16.
Lordship, my
you had no appeal. There's no appeal against this order.
no, but this is the non-compliance of this order, it is the matter of the contempt case, Lordship. No, no, this is a matter of contempt, Lordship. No, it is a writ jurisdiction, Lordship.
No, you want to evade the compliance of the order?
Yes, Lordship. That's why, Lordship.
By raising the technical issue.
No, that's why, Lordship, I have to take some time, Lordship, that to apprise this honorable court, what is the position, Lordship.
Lordship, this writ
But
petition is
Mr.
pending for last
So-and-so-
5 years.
Huh?
Last 5 years
But
pending.
not
Lordship.
reached, no?
The director office is situated next to the High Court. Lordship.
Not reached, no?
Not Mr.
Escadas.
Esqueda, that is counsel for the. Mr. Considering that this court by an order dated by an order dated what is the date of
27/7
order?
Lordship.
(27/07/2012). Has clearly held that has held that the appointments of both the appointment of the petitioner, although has been effected on which one you
26/7/2012.
26/07/2012. Same would relate back to the February 2006, the date on which one Sri Bubul Sharma was appointed. It has also held that the petitioner will not be entitled to any back wages, access, continuity in service for all other purposes, including notional fixation of pay. If you have contingent pay 16, huh? Now, next period. By filing this writ petition, petitioner has spread for conferring him the seniority.
Seniority and gradation.
Seniority
And increments. Seniority gradation
by
and
filing the writ petition, petitioner has claimed for his seniority to be appropriately fixed in terms of the above order by relating his appointment back to February 2006, where one Sri Bubul Sharma was appointed.
Lordship, it will be moved on early. If the petitioner, present petitioner is moved on early, and Lordship, I am sorry, Lordship, the date of appointment is my 11/1/2012.
That change there.
11/1/2012.
11/01/2012. Huh? Next para. Mr. J.K. Goswami,
Lordship.
Learned State Council,
Additional Senior Government.
Additional Senior Government Advocate, President. He may be granted further 2 weeks' time to obtain instruction in view of the clear observation and direction of this court in the above writ petition. In the above writ petition being in above writ petition in above WPC so and so WPC 257 of 2011. Huh? You had that by order. I don't know. Considering above, let this matter be listed after 2 weeks, providing Mr. Roshan additional senior government to obtain instruction.
Lordship.
Apply.
Yes. The electoral process was initiated by the respondent of Provincial Lordship. Due to overdose, the petitioner could not submit their applications. Therefore, they have approached the authority for condoning their age. Lordship, that was not happened. Accordingly, they have approached the Honorable Court. Pursuant to the order of the Honorable Court, they have been allowed to participate in the selection process. Subsequently, result was declared, but their result has been withheld. Accordingly, they approached Island withheld, not declared.
So,
thereafter, they have approached the Honorable Court by IA. Then the Honorable Court asked them to declare the result and to participate in the PST. This is a three-phase selection for this lawsuit. First, written exam, then PST and computer test. Physical efficiency test. PET. Then the Honorable Court has directed to declare the result and allow them to, if they have asked, then allow them to appear in the
physical education.
Yes, but that was not till that was not. Lordship may kindly go to the.
Yes.
Lordship, we received the instruction, Lordship, and I would like to submit submit an affidavit, Lordship, on behalf of the respondent, Lordship.
Saying what? What is the affidavit? What is the instruction?
Lordship.
Have they cleared?
No, Lordship.
Have they qualified in the written test?
It is Lordship. They have some no. They are not qualified, Lordship.
Then, better is there. If they are not qualified, what's there? Direction was there to allow them to appear in the physical efficiency test. If they are eligible or qualified in the written. Withdraw or dismiss. Heard Mr. So-and-so learn counsel for the petitioner. Dismiss.
I did file.
Is it so?
Lordship, I will file an affidavit.
No, wait, affidavit is required.
Yes, Lordship.
It's your instruction is enough.
No,
unless it is correct.
No, my instruction is that, Lordship.
Better,
Lordship. I have to file an affidavit.
Better, sir. It's very simple matter.
Lordship.
They have been allowed to participate in the written examination.
Lordship.
What is the last order? What is the last order? In the IA?
IA, Lordship.
Where you have been.
It's IA 162 of 2021.
Page?
Lordship. It's a separate IA, Lordship.
Okay.
Okay, order date is Lordship 29/1/21, Lordship.
Lordship, it is Lordship, as per my instruction, Lordship, as per the individual score cards provided by the Dibrugarh University, none of the petitioners qualified for PST, PET as their marks are below the cutoff marks. They are not qualified.
Instructions.
Lordship.
So should I record or just dismiss? Close on instruction.
They could not pass the written exam.
Non-qualification may be recorded, Lordship. They are not able to qualify, that should be recorded.
Heard Mr. So-and-so learn counsel for the petitioner. By filing this writ petition, No, no, and also Mr. J.K. Goswami, learned senior, additional senior government advocate. Sorry. Pursuant to the advertisement dated 11/04/2018 for filling up of sub-inspector within bracket UB bracket close. The petitioners have, how many petitioners? One.
No, Lordship. There are nine petitions.
Nine petitions.
Petitioners have participated in the written examination.
Lordship.
Written examination.
Written exam.
In terms of the order passed by this court, wherein the age of the petitioners were considered, were relaxed by making them eligible to participate, right?
Lordship.
After relaxation only.
No, Lordship. We have to ask to approach the authority for relaxation of the age, but we have been temporarily allowed to participate in the written test.
Wherein this court has directed the petitioners to approach the authorities for relaxation of their age and to allow them to participate in the selection process, recruitment process. Accordingly, the petitioners have participated in the written examination. List of in terms of the order, in terms of the interim order of this court, when the result was not declared,
Result
huh?
was not declared. Lordship.
The petitioners, by way of interlocutory applications, being IA 162 of 2021, has prayed for declaration of the result,
Lordship.
and allow them to participate in the next stage of recruitment, i.e. in the PST of the PET test and the consequential CBT. What is CBT?
Computer-based test.
CBT. You write PST means?
Physical standard test.
Did you write physical standard test, oblique physical efficiency test, and the consequential computer-based
test.
CBT. This court, had ordered that 29/01/2021, directed the authorities to declare the marks of the results of the applicants, and if the applicants have secured the cutoff marks in the written test as set by the respondents, no, petition, the petition be allowed to take part in the PST oblique PET test and the consequential CBT. Same you right, huh? Next period. Today, Mr. J.K. Goswami learns additional senior government on instruction, on written instruction, submits that the petitioners have not qualified in the written examination to be allowed to be
as their marks
participate in the next stage of recruitment, i.e. PST oblique PET as their marks
Are as their marks are below the cutoff marks.
are below the cutoff marks. Mr. Considering the above. Having considered the submissions, I find that there would not be any surviving live issue to be determined in view of the fact that the petitioners have not qualified in a written examination. Mr. The learned counsel for the petitioner fairly admits that indeed there would not be any live issue to be determined. Mr. In view of the above, writ petition stands dismissed as in process. Clear.
May it pleases your lordship. Lordship, in this matter, state authority is supposed to file their affidavit in
Lordship.
opposition.
Lordship, we have received our instruction. Lordship, may allow.
What is the matter?
This is
Matter for-
regarding provincialization, Lordship.
Huh?
Provincialization,
Provincialization.
Lordship.
Yes.
We have received our instruction, Lordship.
What is your instruction?
The district scrutiny committee has not recommended the case of the petitioner, Lordship.
Huh?
District scrutiny committee did not recommend the case of the petitioner for provincialization. because,
Why you have not recommended?
There are, based on the enrollment position, the enrollment position of the school was 72.
72.
72, which means 3 teachers, science and math, social studies and languages. And there were other teachers who were senior to the petitioner and teaching the relevant subjects. So their cases were recommended for provincialization, because if it is not
Out of 3 teachers,
after
she is or he is
Language.
language teacher, but then junior to
junior.
the other
Yes,
language
there
teacher.
were other teachers also.
No, lordship. She is much senior to the private respondent number 7.
So was
Lordship,
Hindi teacher. Actually, Lordship, the petitioner is a Hindi teacher. So his name has been not recommended, but last occasion, Lordship has granted some order to recognize the name of the Hindi teachers in last date. Lordship passed an order to reconsider the case.
Let me file affidavit, Lordship, it will clear everything.
okay.
Petitioner is the
Similar order can be passed.
No, Lordship, the petitioner in this case is a Hindi teacher. So his name has not been recommended.
That's why normally she may not have the right to indefeasible right. But I think this code is of the view that there is a scope to have scope of having appointment of additional post.
But that will be allowed only
Therefore,
when the enrollment position is
no,
increased.
consideration can be made
Lordship.
if it can be done in accordance with the right to
Education.
children education 2009.
Lordship.
It's not a direction to,
No.
there's any scope of consideration.
Scope.
That's the issue.
But the only thing is that
lordship, let them file their affidavit.
You find out that order of this court.
Lordship order is
Although we have the directive, but it was not a mandamus. Having considered that there may be there is a scope to consider, nothing else.
and otherwise
If they
also,
cannot consider, better and stay.
and Lordship, otherwise also there is a provision, statutory provision under section 14, they can prefer an appeal
Ah.
against the non-recommendation of district scrutiny committee.
So you find an
So
appeal.
Lordship will dispose of
There are so
in that
many
direction also.
orders.
Lordship, first, let them file their affidavit in
What is there unnecessary? Again, if you find that there is,
Lordship will
there
dispose
are
of
orders
it.
also.
No,
There are
Lordship-
so many orders passed by this court.
yes,
no.
yes, for preferring
To
appeal.
file an appeal.
For
To file
preferring
an
appeal.
But one of the orders, just give me the one of the.
Order is not there, but there is a provision, a manual to the education manual.
I have seen the provisions.
Lordship,
I'm
section,
asking the order passed by the coordinate bench of.
at the moment, I don't have the order, but there are number of orders passed by this honorable court for preferring an appeal. Section 14,
Madam, that will be.
That will be more-
Again. Better, don't waste your time. When is the provincialization? when your case was rejected? Which year?
Appellate authority, Lordship section 14 says.
No, no,
Yes.
Petitioner authorized, Lordship 5/2/2021. 5/2/2021.
2021, the provisional order was
Yes,
issued.
it's 5 years. Don't waste your time. Ultimately, tomorrow, if we say that no, you have to file an appeal, so writ petition will be dismissed unnecessary.
Yes.
Or else you withdraw and will give you a liberty, will provide a liberty to approach the appellate authority in terms of the.
Lordship, for that I have to take instruction from my senior. He is not here now, Lordship. So Lordship may fix a date for that. And
Who is your senior?
Mr. S.P. Chaudhary.
Huh?
Mr. S.P. Chaudhary, Lord.
He's not around.
He is not here, Lordship.
He's not around. In the premises of the High Court.
No, Lordship.
Where he is? He's on a holiday.
No, Lordship.
Our holiday is yet to approach. I mean, it's approaching only. We have another 20 days to go. Why is on advance holiday?
Lordship may fix a date on that date.
And MS learn counsel for the petition. Mr. S.N. Sharma, S.P. Sharma,
PN Sharma,
PN Sharma, learn counsel.
Elementary Education Department.
The study because the Elementary Education Department submits that he has received the instruction. He has received the instruction from the authorities. Therefore, therefore press for 2 weeks time to file affidavit.
Okay, I am for respondent 7.
3 weeks, Lordship, otherwise also, because they are not willing to prefer an appeal. So by 3 weeks, I will mention.
3 weeks. Huh?
Lordship.
I am for respondent number 7. I have
No,
respondent 7.
no,
Respondent 7.
this is the matter of the 3 weeks.
Lordship may fix a
In the
date.
meantime, the land standing council to file their affidavit. Mr. So-and-so is present. For land council for respondent.
Number 7.
Yes.
A date may be fixed, Lordship.
Obligers.
Obviously.
Yes, matter relating to the pension and pensionary benefit.
Yes.
So, last question, my lord, by order dated, and in the meantime, my lord, you are directed to pay the provisional pension.
You have appeared. Have you appeared?
Lordship, I have appeared for the, but my signature is not required, my lord, because this is the fixation letter. Earlier they fixed.
On appearance, what had happened?
My appearance is not required, my lord. No.
You have said on last occasion, you said you want to appear.
Yes, my lord. I appeared before the inspector and director also. They said that, yes, your signature is not required, so we are going to finalize. And earlier they have finalized.
They are going to finalize.
It is their case, my lord. Once they have submitted the pension papers before the director of pension, and that was returned due to some mistake. And now they are saying the refixation.
They said they'll refix it, finalize everything. Wait for some time.
Let them file affidavit, my lord.
What affidavit?
Because they are disputing their own, they are doing wrong.
Last occasion, what you said is you're Mr. Nath.
Yes, my lord.
Submit that in view of the direction issued by the court-wide orders, the petitioner has to attend the office of the principal.
Yes, my lord.
With regard to issue of refixation pay of the petitioner.
Refixation, my lord. Earlier they have fixed wrongly. Now they want to refix.
You appeared.
Yes, my lord.
Did you appear?
Yes, my lord.
So they said
they have
finalized.
They have prepared. They have sent it.
Yes.
But my only prayer is that, my lord, there was an order for releasing of my provisional pension.
Yes.
That letter dated. By letter dated, your lordship will find directors as directed to order dated lordship will find 3125 IML, IN number, IS civil 6625. As per the director's order, IR lordship will find in IA. Till finalization, the order was passed to
and provisional pension of rupees 39,000. 39,000. Till finalization, madam. That was paid for 2 years. And from 1st January 24, that is been stopped. They are saying that, my lord, so their own director's direction, although they have sent the bill to the treasury, that was returned due to some mistake.
Which one?
They have to correct, madam.
Project provisional pension.
Provisional pension, provisional pension.
Lordship, I have the up-to-date instruction.
Yes.
Lordship, with regard to the provisional pension, initially it was sent in a manual manner. The treasury officer rejected it, and now they have sent it through online. Today, I think during the course of the day, Lordship, it will get credited to the petitioner's account. And with regard to the finalization of the final pension, Lordship, the proposal, everything after refixation as directed by the Director of Pension, it has been prepared. It will be sent to the Director of Pension within a day or two, and thereafter Director of Pension will issue the final PPO. Lordship.
That's so.
So we'll close the matter. We'll close the matter. We'll record the submission and we'll close the matter.
No, my lord, matter may be pending because matter may be taken
Why
after 2 weeks.
unnecessary?
Because, my lord, because a lordship will find as per their at 24/5/2000.
We're disposing.
For last,
We're closing the repetition.
no, my lord, I have also other, in this, there is also other prayer. Lordship may see the prayer regarding area salary and other things is there, not only pension. The petition prayer is regarding.
No, as of today, you cannot ask for everything. Right?
Because
Now, the first issue is provisional pension.
provisional pension, yes,
They are
my lord,
ready
that is,
to, that will be credited today,
yes, yes.
by tomorrow, whatever. Just a technical issue.
That may be recorded, my lord. I am on this.
No, we're not on piecemeal. Number one. Number two, you are claiming for regular pension or whatever salaries, whatever is there. They say there was certain technical issue that has been rectified and it is under process.
Yes, yes, lordship. Then,
It will be finalized.
then matter may be fixed for after a week, my lord.
Why?
Because
In view of this, when they are taking the.
then I have to again come. If they do not finalize within a short period, for last 3 years, they have to make it
We cannot.
for last 3 years, my lord. Because my prayer is that, my lord, regarding arrear salary claim is also there. Arrear salary.
That's what I'm asking you. You cannot ask everything at a time. What is your entitlement? You will have to show. Anyway, it's up to you. If you just want, if you are happy to, happy to keep the petition pending, it's up to you.
Next date, my lord.
But think about,
After
sir,
2 weeks.
sir, think about your client.
2 weeks, my lord, after 2 weeks.
Huh?
Because in the meantime, they may finalize. Because for last 3 years, they are saying that today or tomorrow we'll finalize. Like
Mr.
this,
So-and-so learned counsel for the petitioner and Mr.
B. Chaudhary for BTC.
BTC. And who else are there?
I'm for the
So-and-so.
government, madam.
Next parent.
9 and 10.
said to come again.
Lolo. Although, this court was of the view that the writ petition could be disposed of, considering that the matter relates to claim of provisional pension as well as pensionary benefits.
Benefit.
The learned counsel on the insistence of learned counsel for the petitioner to keep the petition pending, this court is constrained to adjourn the matter for further 4 weeks. Please.
That may be recorded, madam. They have stated that we finalized within 1 week. That statement may be recorded.
Sir, they are giving you everything.
For
don't
last
want to
three,
take it.
for last 3 years, my lord, they are not finalizing.
You appears that you would be happy to keep the petition pending.
But that may be recorded, my lord. They have stated that they will finalize within a week. That may be reflected.
256.
Yes. It is expected that the respondent authority shall consider payment of pensionary benefits as well as finalization of the other pensionary benefits within a reasonable period of time.
That
Want to grant you relief, you don't want to take the relief. What can I do? Yes.
My lord, in this matter, my lord, you file affidavit. I pay for 10 to file reply affidavit.
What is the matter?
Matter relates to family pension.
They are disputing.
My lord.
Are they disputing that you are not entitled?
No.
Then
Entitled. He's entitled to pension.
so what reply would you?
My lord,
If they are not disputing your entitlement.
my lord, though they have released provisional pension as well as some area salaries, lordship, but subsequently they are not releasing GPF, GIS, and with salary of the petitioner. They are saying
And
that
Mr. So-and-so, counsel for the petitioner submits that he has received the affidavit in opposition filed by the respondent number,
Additional affidavit.
additional affidavit filed by the
Respondent number 2.
respondent number 2, i.e. which you were
The Director of Health Services.
Director of Health Services,
Assam.
sir, to which he would like to file reply. Mr. Therefore, we praise that. I praise for adjournment of the matter. 3 weeks.
2 weeks, lordship.
2 weeks, of course.
Already that is lordship.
Highly
Obliged.
Praise the Lord, huh? Praise the Lord. This after 2 weeks, for 3 weeks.
May it please your lordship.
Yes, sir.
My lord, in this case, my lord, I am non-payment of my gratuity and leave salary.
Yes.
On that issue, my lord, I clearly mentioned that it has not been paid when I am legally entitled. As per law also I am entitled. But this honorable court asked them to, my lord, clarify that point.
Yes.
Your lordship kindly see order dated, my lord. Order dated 27/9/2023.
Yes.
That, my lord. The Mr. Royal Learned Council has placed on record where the instruction has been shown, so it has been said. The Learned Senior Consular Petitioner, however, disputed that the claim has also been submitted that there is no response on the respect of leave encashment, benefit, and gratuity. So now they file an affidavit. In affidavit, my lord, even my lord, our para has not been answered. They simply say it, my lord, in para 4. Your lordship kindly see in their affidavit. In response to that, they have filed affidavit.
Page.
Affidavit, my lord, your lordship will find affidavit dated, my lord.
Additional affidavit.
Yes,
Filed
additional.
by 456.
My lord,
5 and 6.
para
Yes.
4, my lord.
Yes.
The answering respondents humbly beg to state that with regard to the payment towards the encashment of benefit of gratuity, and North Guwahati Municipal Board has not yet implemented the scheme, considering the shortage of fund position of the board. On the other hand, the government has no such provision for giving benefit toward the retired and expired employees directly from them. So, my lord, that is absolutely, my lord, against the law. Your lordship kindly see.
Yes.
Your lordship kindly see page 8, para 8 of my affidavit in reply, that is page 25, my lord. Page 25. Page 25. Para 8, my lord. That's deponent, that is my affidavit, madam. That's deponent beg to state that the stand taken by the respondent authority that the board has not yet introduced gratuity and leave salary, and hence the release of the scheme does not arise. It is not at all correct. As per the government circular dated so and so, as per the section 50 of the sub rule 3 as well as section 51 of the Assam Municipal Act 1956, the deponent is entitled to get gratuity and leave salary as a retired employee of the board, and there is no question of newly introduced in the same. In fact, the employees of the other municipality board, Assam, like Rongia Municipality Board, Nalbari Municipality Board, are getting gratuity and leave salary after retirement as per circular dated 24/7/2023, 2003. That is not been addressed, my lord. They have not answered, my lord. There is a circular. Your lordship kindly see that, my lord. Circular, that is, my lord, page 30. Annex B. That is, my lord, applicable to all municipality board, my lord. Why not not Guwahati municipality board, my lord? That is not been answered. Page 30, my lord. Director of Municipal Administration.
They have not framed the rule.
My lord.
They have not framed the rule as yet.
So that, my lord, in pursuant to the government circular, other, my lord, municipality board cannot frame rule, my lord, from their own, my lord. That is governing, my lord. The government director of municipal administration, my lord, circular will be there, my lord. And as per rule 50 of the, my lord, Assam Municipal
This
Act.
order appears to be for the time being. Are you not getting this?
I am not getting my gratuity and my leave salary, which I am entitled to as per law.
No, we said in order to mitigate the hardship, the return as an ad hoc arrangement for payment of debt come retirement gratuity.
My lord.
This is what you want.
Yes, my lord. Because in respect of Rongia, Nalbari and others, my lord, they are getting, my lord, leave salary and that is not been answered, my lord, in the affidavit. That's why I am pointing out.
Your lordship, if my learned senior is complete, then I will.
Yeah.
My lord, I complete, my lord, that is good.
So
The rest is not the issue.
Rest, my lord, other salary I have received. Only gratuity and leave salary.
Gratuity and leave salary.
Your lordship, the municipal board established under the Municipal Act, they are all self-financing independent autonomous body receiving grant in aid only from the government. Otherwise, with regards to regulation of their own funds as to how they spend that particular funds in their own areas, that is totally the discretion of the municipal board. Now, as I have stated in my additional affidavit, if your lordship has perused through that, paragraph number 4, we have stated clearly that we do not have any such scheme because this particular board as such is already facing financial crisis. And it is not the case that a petitioner, all of a sudden, he raised this particular issue. He joined this service in the year 1989. And since 1989, and he retired in the year 2022. After retiring, he filed this representation seeking leave encashment and gratuity, knowing all the while he was working as an executive engineer. All the while he was knowing that there is no such scheme. He could have raised this particular issue that he wants to be paid this retirement gratuity as well as leave encashment.
Section 50 and 51?
Your lordship, with regards to this, that's what, your lordship, we do not have any rules as such. We have not framed any rule with regards to payment of leave encashment and gratuity.
Let us see, rule 50 and what rule
My lord,
50 and
no, there is
51.
that is the act, my lord. Means Assam Municipal Act.
Yes.
My lord,
At best,
municipal-
your lordship, if I can say,
Sorry,
his
section
representation,
50 and 51.
if
No,
I
no,
may
your
submit, your
lordship,
lordship,
one thing, yes.
if I may submit at this stage, your lordship, his representation is pending. His prayer is that his representation has not been considered till date. That is what he has stated in the affidavit, in the writ petition. So if I may pray before his lordship, this writ petition may be closed. Let direction be issued to the North County Municipal Board to dispose of the
No, I am
representation
not
as
agree
to,
on that, my lord.
why he will not get, because a positive mandamus, if it has to come from this honorable court, something has to happen with that representation, your lordship. That representation has to be decided upon, whether or not he is entitled to get that particular.
So which is stopping why the direction is required to consider the
No, my lord, I am
representation?
submitting, my lord.
Grant any kind of direction to
No,
that
but
effect,
no,
your
it's
lordship.
not required to be issued to consider the representation.
That representation is
Which
otherwise
is
pending,
stopping
your
you?
lordship.
You consider it.
Otherwise, your lordship, because there is no, because we do not have any scheme as
So
such.
let us
No,
see.
they-
And it is not the case that he is not aware of that
Section
particular scheme.
50 and 51. I've not seen it, that's why.
Oh, yes, my lord. Sorry, my lord, this is, Assam Municipal Act, my lord.
Section.
My lord, this is. My lord, pension and gratuity and leave salary always, my lord, claim after the retirement. I cannot cannot, my lord, claim my gratuity in the joining date, my lord. It is always after my retirement, my lord. It's a retirement benefit, my lord. Section 50, my lord.
No, just
And my lord, that's why my lord, government, my lord, affidavit is very required, because my lord, other municipality are enjoying, why not, my lord?
They are different boards, your lordship. And if I may take your lordship to section 50, subclause 3, if I may just read out, your lordship. If I may just read out, section 50, clause 3.
just wait, just wait. Yes.
Yes. If I may take your lordship to 53, gratuity or pension. If I may just read out, a municipal board may, I lay stress on this particular word may, at a meeting, time to time, make rules for gratuities or pension to be granted and paid out of its own fund to its established subject to the approval of state government. May, your lordship, it's a discretionary clause, your lordship. It is not a mandatorily gratuity has to be paid. If it is the case that shell was used, then yes, we should have paid him. It's a may, subject to his own fund, out of his own fund. If we do not have the funds, that's why we have not framed any rules. It is not a mandatory clause, your lordship. And this is just an office order. An office order cannot override the particular section of the statute, your lordship.
No, since you have not framed a rule.
Yes.
Right.
Yes.
This page 30, annexure B, it will apply.
No, your lordship, I humbly disagree because it's not a mandatory clause. It's the language used in the municipal
See, it's
act
your
is
decision.
says.
This is, sir, is it for you, what you are claiming?
My
Are
lord.
you claiming under this?
Yes, my lord.
24/7/2003.
Yes, my lord, in persons to it, my lord, by virtue of this, my lord, other municipality has, my lord, giving, your lordship kindly see.
Payment of debt, retirement.
Yes, my lord,
gratuities.
these are, my lord.
Huh?
Yes, my lord.
It is out of his own fund, your lordship, out of his own fund.
No, that, my
Your
lord, this is-
lordship may
No, but
kindly
this
note the
is
language.
municipal administration is not for all.
It is all, but this particular municipal administration
See, you
cannot
have not,
override the.
admittedly, you have not framed a rule.
No, we have
Let
not
us-
framed the
Let
rules.
us, I mean, accept that for a time being.
Yes,
You have not framed a rule.
we have stated in affidavit,
Since,
additional affidavit
since
also.
without, since you have not framed a rule, by way of supplement, this order has been issued.
Your lordship, a supplementary order cannot override the
are you
mandatory
dis-
clause of a statute, your lordship. I'm sorry to say this, your lordship.
I
we have to
understand.
we
You
do
are
not have the
supposed to
funds.
frame a rule. You have not
May, your
frame a
lordship,
rule.
because we are not supposed to, your lordship. If the language here uses may, it is not a mandatory clause, it's a discretionary clause, subject to availability of funds.
This is not as simple it is.
In
Sir,
my humble submission,
it's
it is
not
it is simple, your
as it
lordship.
is.
It is dependent on the availability
When
of funds, your lordship.
that's, the discretion cannot be unfettered.
Discretion, I agree. but
Discretion cannot be unfettered.
it is dependent on the availability of
You
funds.
just cannot say that only may is used. You cannot.
Your lordship, it is subject to availability
You
of
will have to
funds.
read entire act,
I agree, your lordship.
not only one line,
In
one
fact,
word.
this whole section itself, the whole section 50 itself, your lordship, the language used is may. It's a discretionary clause.
Whose
your lordship.
letter is this?
This office order is the Director of Municipal Administration.
Director is-
So
Perhaps he may not be aware of the particular clause, the mandatory or
clearly it
discretionary
says,
clause, your
you
lordship.
read it.
Your lordship, I've read
You
it, your
read
lordship.
it.
I've read it, your
Please
lordship.
read it.
I've read it, your lordship.
Due to
But at the same
non-framing
time-
of gratuity rules by the municipal town company under the provision subsection 3 of section 50 of the assumption, therefore, in order to mitigate the hardship of the retired employees.
Your lordship, this is subject to rule as it is said, subsection 3 of rule, section 50 of the Assam Municipal Act.
Yes.
So if suppose the subsection 3 of section 50, this is dependent on that particular section, it clearly says so. So if we go by the language of
You read,
subsection
please.
3,
Come to page 30, read and.
I'm reading it now,
Letter
29, your lordship, page
Office
number
order.
29, your lordship.
Huh?
This page number 29, office order annexure B.
Yes, read it.
I'm reading out, your lordship. It has been found that considerable hardship is being faced by the employees of municipalities and town committees, corporation computation of gratuity after retirement from service due to non-framing of gratuity rules by the municipality towns under the provision of subsection 3 of section 50 of the Assam Municipal Act 1956. Therefore, in order to mitigate the hardship of the retired employees, as an ad hoc arrangement for payment of death cum retirement gratuity shall be made, your lordship. Your lordship, in my humble submission, your lordship, a mandatory clause cannot override a particular discretionary clause which is enshrined in the particular section. That subsection 3 of section 50, your lordship. My humble submission, I can produce judgments to that effect, your lordship. An office order cannot override the mandatory statute. your lordship.
Sir, I'm
It is
quite
not over.
aware of that. I'm conscious of that.
So, your lordship,
I'm not oblivious to the law settled by the
let me
Supreme Court.
substantiate this particular by placing judgments, your lordship, to that effect. By placing judgments to that effect, your lordship.
Do you think this court is ignorant of that law?
No, I'm not saying that, your lordship. I'm not saying that at all. I just want to assist this particular court by placing some judgments, your lordship.
I ask you to read this.
Yes, your lordship.
This can be treated as a supplement to which is not in the rule. You are supposed to, you have a discretion to frame a rule, right?
Yes.
And your administration, considering to mitigate the hardship of the employees, has issued an order because there's no rule framed by the board.
Your lordship, that is my humble submission, subject to availability of funds from his
No,
own
there is
fund.
not there. By
Subsection-
divisionally he is making a
subsection 3.
submission. There is no
Subsection
subject, fund, your lordship.
Subsection 3,
Again,
if
I
I
am
may
reading
just
my
read out, your
Again,
lordship.
I am your lordship.
Let me just read
Sir,
out
just
subsection
wait.
3.
I just want
No.
That's why I want him to read.
No, that's why he's not he's reading something.
Lordship,
submitting
subsection
something
3
else.
itself says from his own fund, from the municipal board's own fund. How do we
Obviously,
generate the
from
funds,
where?
your lordship? If we do not have the funds, your lordship, because we are a self-financing body, receiving only grants in aid from the government, Department of Municipal Administration. If we do not have the funds, then where from we'll actually get those funds to pay the gratuity?
Sir, are you not under the municipal administration?
We are just receiving grants in aid.
Are you not, you're not regulated by the municipal administration?
No. Section 50 itself, your
You have
lordship.
nothing to do with the municipal. Directorate of Municipal Administration.
No, if I may just.
How
read out-
do you function?
Yes, it's an autonomous body. Section 50 says so. If I may just read out with regards to everything, pay, gratuity, everything. Subject to a particular benchmark which is notified by the Director of Municipal Administration. That's why I'm saying it's a discretionary clause. If I may just read out right from section 50 itself, appointment and pay of establishment. If I may just read out.
Thank you. You are allowing the writ petition.
Your Lordship, this is totally against this particular judgment. Many
Give
judgments.
us the judgment.
I'll produce it. Your Lordship may grant me.
Sir, I am
2 days time,
repeating
Your Lordship.
again. I am not
Lordship may take it up on
oblivious to
Monday.
those judgments. Are you think that this court is ignorant of those
I'm
laws?
not saying that, Your Lordship. I just want to assist Your Lordship by placing those
Please.
judgments, Your Lordship. So if Your Lordship may take it up on Monday, Your Lordship.
Please assist the court.
If I may just take
Don't-
it, place
don't
them
try
on
to
Monday, Your Lordship.
Don't try to be over smart and to school the
No,
court.
I'm not doing so, Your Lord. I'm not doing so.
We're here after considerable experience in the profession.
We do not have this particular scheme, leave encashment benefit, as well as gratuity, Your Lordship. We have stated in an additional affidavit.
Are you disowning this?
Your Lordship,
Page 29. According to 29, it's page 30.
Your Lordship, I'm saying that this
Office
particular
order.
office order,
3407 2000.
this, I'm saying this office order goes against the ethos of subsection 3, section 50 of the Municipal Act.
Sorry.
That is what I'm
You
saying.
have the discretion to frame the rules, which you have not.
Your
Right?
Lordship, Your Lordship may order accordingly.
Forget about the ethos. Give me judgment. Which
Right now, I don't have those judgments, Your
Then-
Lordship, because
why
right now, I'm,
you are on the judgment?
Your
When
Lordship,
you
right
don't have
now,
the
I'm,
judgment.
right now, I don't have it at hand, Your Lordship. That's why I'm praying, Your Lordship may take it up on Monday. I'll produce the judgment.
Therefore, because this court is ignorant of those judgments.
Your Lordship may pass any
Those
order,
law.
Your Lordship. Your Lordship may pass any order. I bow down.
Anyway,
Well, one thing I make it clear, my lord, section 3, gratuity and pension, but nowhere stated the subject to availability of fund, subject to approval of the government. Only line is there, my lord. Your lordship kindly see.
no,
And that's why I'm not frame same, that's why the
I'm-
supplement that,
no,
that is,
sir, I'm sorry
My lord.
I'm sorry to, I mean, I might have used.
and also this is
The
sent to all the
board may not be-
municipalities.
may not be
They are, that is,
appropriate.
they are bound to follow
Appropriate,
this. my
sir,
lord.
just wait. You are in a rush, appears to be in a rush. That's why I repeatedly told you to read the section and the order of the office order issued by the Municipal Directorate of Municipal Administration. At the convenience of the municipal board, if you ignore the order passed by your administration, is not it? How the system will function?
Your Lordship,
Forget about this particular case.
Your Lordship, he was there all this while since 1989. He never raised this issue. He was all there. If we have to pay him, then we have to
See,
pay all
I'm
the
not-
past
I am
employees as well
I'm
as the
not
future
saying
employees,
that
Your Lordship.
you
Where will
have-
we get
you
the
have
funds? Your
framed
Lordship?
the rules. Admittedly, there's no rule.
There's no rule, Your Lordship.
The administration, in view of the non-framing of the rules, may not be mandatory, right? You may have the discretion to frame or not to frame. But then considering the hardship faced by the employees, this is issued by the administration,
Your Lordship, it is
your
not,
administration,
it is,
municipal
it is not the
administration.
case that they are only facing the hardship. In fact, we are also facing the hardship with regards to funds, Your Lordship. If we do not have the funds, how can we
See,
pay,
funds,
Your Lordship?
for funds everywhere, individually or collectively, there's a problem of the fund. Not only in India.
I agree.
What is happening in America also?
I totally agree, Your Lordship. I bow down on this issue.
Yesterday,
But-
have you seen how is it happening? What happened to Tesla? What would be threat of the Tesla? The world's richest man, Elon Musk. Everywhere there is a fund problem. So that just cannot be an excuse. And there is, mind you, sir, please, there is judgment of the Supreme Court also. The non-availability of the fund as well as the paucity of fund cannot be a ground to refuse the entitlement of the employees. You read that also. So we're fixing it on Monday. As desired by Learned council for the response. You are for municipal.
I am for respondent number 4, 5, and 6, not Guwahati Municipal Board.
Guwahati,
One, not Guwahati.
not Guwahati. This is of not Guwahati only.
This is not Guwahati. These are
Why
not-
not dealing with the municipal board of Itanagar or something, Dibrugarh or something?
No,
like
not Guwahati is not a very financially independent body. Your Lordship.
Which
It is
is the-
already in loss.
Who is having the highest fund in the state amongst the board?
Guwahati, Your Lordship.
Then
This is not Guwahati. Other side. This is Guwahati is a Guwahati Municipal Corporation different.
appears to be
Not
you are-
Guwahati is different, Your Lordship.
you are not able to manage the fund from the government.
No, Your Lordship, we have not received. We have received lately. In fact, his salary was not paid for 26 months because we did not have the funds.
Even if
And
you are
now only it has been paid.
see what is the note?
I'm
What
sorry,
the note denotes? It's not Guwahati.
not Guwahati.
What the notes denote? NORTH.
Not. Lordship, I'm not aware, Your Lordship.
You find out. Search from the Google what it denotes. And Mr. This among the Landing Senior Council Assistant by he was the Landing Council. After hearing the letter at some length, on the prayer of Mr.
D.
Yes.
Bora.
Huh?
D. Bora.
D. Bora, London Standing Council,
4, 5, and 6.
London Standing
Not
Council,
Guwahati Municipal Board.
Guwahati Municipal Board. List this letter on Monday.
Hello.
So as to enable him to place the case loads which he has heavily relied on. Yes, sir. Okay, thank you.
Yes,
We'll hear
obliged,
you on
Your
that.
In this case, my lord, respondent number 3 has filed affidavit, my lord, and others has not been filed. And so I pray for 2 weeks time to file affidavit in reply.
2 weeks time.
Yes, my lord.
My lord, I am on behalf of the respondent number 2, my lord, APSC, my lord, we are formal party probably. We have already recommended his name. Government not appointed, no?
Either day.
My lord.
Your name has been recommended.
Yes, my lord. I was selected for the post of
For the
BDO,
post of
my lord.
Why
video,
you have not been selected, appointed?
but the government has to file affidavit, my lord.
Yes,
Government has filed affidavit. Respondent 3 has filed affidavit.
I'm not questioning the authority, but why? What's the reason? What's the reason?
My lord, they are saying that the petitioner is a PWD candidate, my lord, and he has submitted the PWD certificate where they are saying that 50% hearing disability is there. And now they are saying after the examination in the year 2023, they are saying only 23% is the hearing impairment of the petitioner.
So
There's a dispute. my lord.
what is the
Because
actual disability?
It's a
Percentage of
50%, my
disability?
lord. It requires 40%.
According to you, 50, but according to them, at
Then
23.
23, my lord, after the examination.
How it
That is
was
not
examined?
disclosed.
How it was examined? By whom?
There is this certificate of my lord. I have produced the certificate of the disability in the year 2016, which is issued by the government, my lord.
This is in respect of which recruitment?
APSC, my lord.
APSC.
Yes, my lord.
You will direct them to constitute a board, neutral board of doctors to examine you,
Re-examination, my lord.
re-examination.
In the meantime, my lord.
Otherwise, because you are saying that it's 50%, they are saying 23. Which one you cooperate? Because it would be in case, I'm not saying you are not 50%. In case, if you avail the quota, which is meant for those really deserving candidates, without having that required percentage, that would not be fair. And if you somehow obtain the appointment also, if I'm saying, if you are not, if you don't have that percentage, it will haunt you in your entire life. So I think better we should direct them to
Re-examine the petition.
re-examination.
My lord.
You take a instruction from your client.
My lord.
It would be better. Because we cannot decide which certificate is
I will take an instruction from
which certificate government or your to be I mean, relied on. And definitely, I mean, I'm not deciding.
Yes, sir.
Privacy, government will not, may not lie. Unless you some, you can show some malafide or some bias or something like that. Are you alleging any malafide in the
No,
petition?
I'm not alleging that.
So better to take an instruction.
My lord. Next.
And my privacy, the privacy view of the court is to have a reexamination by
Medical board.
medical
by
board,
constituting a medical
independent, I
examination.
mean, medical board,
Right.
like GMC and other reputed.
Yes. Next week, my lord, I am taking.
Hard Mr.
A borrow.
Learned counsel for the petition and
I am for respond number 2, my lord.
Mr. TJ Mahanta, learned senior counsel, assistant.
Sharma.
For respond number 2.
My lord.
Yes, who else appearing? Which department? PNRD. Government is not the part.
PNN, they are separate standing council for them.
Upon them for fixing next week.
My lord.
Considering the nature of the grievance raised in this petition with regard to the percentage of disability, what is that? What disability?
Hearing disability, hearing impaired,
Hearing impaired,
50%.
hearing impaired, huh? Comma. The petitioner is granted a week's time to obtain instruction from the petition. The learned counsel by the petitioner is granted a week's time to obtain instruction in view of the privacy view of this court to have an examination of the petitioner by a board of doctors in accordance with the applicable rules and act. This after 1 week.
Develop, oblige.
May please your lordship,
Yes.
on behalf of Animal Husbandry and Veterinary Department, Standing Counsel, Mr. M. Kotoke. Since out of station because of the sudden demise of her mother-in-law. Her absence letter was already submitted, my lord. My lord,
You are for respondent.
yes,
Respondent, Mr.
Miss M. Kotoke, Standing Counsel of Animal Husbandry and Veterinary
Yes.
Department. I'm on behalf of her. She was absent because the sudden demise of her mother-in-law. Her absence letter was already submitted, my lord.
Or MS so and so learned counsel for the petitioner. MS so and so learned counsel for the learned counsel
Animal
submits that appearing on behalf of MS
Kotoke.
Kotoke. Learned standing counsel for Animal Husbandry and Veterinary Department. Submits that MS Kotoke is in bereavement. List of therefore says that matter may be adjourned to 2 weeks, 3 weeks.
Much of
This for 2 weeks. This is the matter of the 3 weeks.
I'm sorry, my lord. In because item 15, my lord, there is an interim order that may be continuable, not to fill up the video post.
Post of what?
Video, my lord.
Video.
Okay, again.
Interim order, huh?
I'll let my lord.
May I please your lordship? Lordship, at the last occasion, lordship, Mr. N. Khatania takes time to file affidavit, lordship. The same is ready to file. So, lordship, I am praying for short
Yes.
accommodation.
Yes. Ask Mr. Answer, learn counsel for the petitioner.
Lordship.
And then so and so. Learn counsel. You are standing counsel.
Education department, lordship. Elementary education department.
Submits that an affidavit would be filed during the course of the day.
Lordship, no lordship. We are sent it for waiting lordship, but that may be taken.
Be filing shortly, therefore, phrase that matter be adjourned, matter may be adjourned after. Major adjourned for 3 weeks. Praise the Lord. This is matter after 3 weeks. In the meantime, the responsible authority is to file the affidavit.
That after 2 weeks.
3 weeks. Hands up.
Well, two other matter, Lordship, same issue have already been heard by the Honorable Justice Robin Pukur, and matter has been kept as CB. Can it be taken?
What is
up
the
with-
matter?
Well,
What is the matter?
matter relating to pay scale. We are seeking a graduate school of pay that was given earlier, but same was withdrawn subsequently.
Because you are not entitled
Yes,
under the act.
my lord.
So,
No. Yeah, in view of the Lordship one judgment of this honorable court, but their judgment is very categorical. Subsequently, Lordship, this is the third.
Mr. M. Khan, learned counsel by the petitioner, who submits that analogous matters have been heard by coordinate bench of this court, for which the judgment is awaited.
Yes.
Therefore, he prays that matter may be listed after. Is there interim order?
No,
Is there interim order here?
there
No,
is maintained.
listed after the disposal of those,
The 3 weeks, Lordship, we
after
can,
the disposal of those writ petitions being, give the number.
WBC 3075/23 and 4353/20.
3035. Right, but no, analogous matters being writ petition so and so number. Then you must put those writ petitions, the above writ petitions down. Accordingly. List this matter after disposal of WPC so and so. There is no problem in passing that order because nobody will be prejudiced. 21. Yes.
Hey, please.
Yes, sir.
This is regarding non-payment of family pension.
Yes.
My husband was a member of APRO, Assam Police Radio Organization. He was a member, my husband was a member of the APRO, Assam Police Radio Organization. Now he expired sometime in May 2020 while in service. So my husband, my lord, initially married one lady. That marriage was dissolved by the family court by a consent decree. Now subsequently he married. Now in the meantime, my lord, my employer sanctioned some amount in my favor. Kindly see page 33.
Page
33, my lord, 33.
33.
Yes.
Yes.
This is the amount already sanctioned in my favor. Can you
Yes.
see? Provisional compassionate family pension of so and so per month is hereby sanctioned to Aparna Talukdar. He is the petitioner here. Wife and legal heir of late so and so. The deceased employee. And also provisional family pension of so and so.
Yes.
Then also, my lord, page 34. An amount of 536,560 against leave encashment was sanctioned in my favor.
536,560.
536,560 in my favor. That is a sanction letter, already sanctioned, my lord.
Yes.
Now,
Both this,
subsequently,
33 and 34.
my lord. Subsequently,
30 and 34 already sanctioned.
Sanctioned.
Yes.
Subsequently, when happened, my lord, they transmit my pension papers to the office of the AG. AG return it back with a request to resubmit it after compliance of certain conditions, additional documents. Now, kindly see this page 41. Page 41.
41.
Yes.
Yes.
Inviting reference to the subject so and so, I am requested you to kindly furnish the following documents to reach this office urgently, as sought for by the AGSM, and resubmission of the family pension. These 4 documents. Next of kin, copy of marriage certificate, self-attested copies, and attested copies of the decree of divorce. Now I comply with 1, 2, and 3. 4 I could not comply. The reason being, my lord, my predicament was that when I approached this family court, they informed me the decree could not be prepared because this original record could not be traced out. The judgment is there. Can you see the judgment, page 29? It's a judgment of the family court.
This birth certificate of child Ankita Thalukdar.
Everything was complied with. Only dispute is about non-furnishing of this
Birth certificate.
decree of divorce. Decree.
Where it is? What is the requirement of that?
Absolutely. Madam, can you see page 29?
No, just wait. These documents, it consists of 4 documents.
4
No, I mean,
documents.
7, what is?
Yes,
4
4
documents.
These are the additional requirement, my lord, sought by.
No, next of kin certificate you have submitted.
Yes.
Copy of marriage certificate.
Submitted.
Copies of the ID, voter
Yes,
ID,
submitted.
PAN card, Aadhaar card.
All submitted. Admitted facts.
Then birth certificate of?
Admitted facts. Submitted.
Birth certificate of child Ankit. Then what is required?
4 attested copies of decree of divorce.
Yeah.
They are insisting for decree. Now judgment is there. Can you see page 29?
Kartar Kaur. Which Kartar Kaur?
This is my first wife. First wife of my husband.
His name is there in the service book.
No.
Our name is.
My name is there. My name is there.
Was the requirement of furnishing this decree of divorce?
Exactly. I don't know, madam. I fail to understand. Can you see page 29? There's the judgment of the family court. It is already there.
Why decree was not prepared?
This is an absolute hyper-technical, my lord, approach adopted by office of the AG.
No, why a decree was not prepared?
Because the family court failed to submit it, my lord, to me. On the ground, the decree could not be prepared because this original record could not be traced out.
1995.
Yes. Page 29. This is the order of the family court. Can you see?
So who is refusing?
AG.
Yes, where is AG?
It seems that there is a letter, my lord, at page 35.
35.
Yes.
Where is page 35?
Yeah.
Yes.
My lord may read A. As per entry recorded in so and so, the name of the so and so, Srimati Aparna Talukdar, but on scrutiny it is found that 2 different next of kin certificates have been submitted along with pension case, the details of which are appended below.
Kartar Kaur, Ankita Talukdar. Who is Ankita Talukdar?
Now that apparently she is the daughter from that first
First
wife.
son.
First marriage. First marriage.
First marriage.
So you have submitted the.
Yes. That was complied with.
Have you submitted the judgment of?
Yes. Every
copy of the judgment?
Can you take up this affidavit in opposition of the respondent number 6? We come to page 45, running page 45, madam. Para 6. As per later dated so and so, senior accounts officer, office of the so and so, returned the family pension case of so and so, stating that the family pension case could not be finalized due to certain observations and requested to resubmit the same after correcting the observation in the complete shape along with attested copy of decree of divorce, as well as other required documents like next of kin, etc. In this connection, several correspondence were made with so and so. PAN, Aadhaar card of Aparna Talukdar, next of kin, had already been resubmitted for resubmission of the family pension case. But she had not submitted a certified copy of decree of divorce to this office, for which the respondent could not resubmit the family pension case. That is the reason for this impasse, my lord. Also read para 9, my lord, last 3 lines.
Yes.
I will kindly appreciate by this page 33 and 34, a certain amount has already been sanctioned to me. Thereby, the government has recognized my status as a legal wife.
But
Yes.
say, is there the first wife is making any claim?
No, no. No.
Page 35 shows that there were two certificates.
No, that was not the reason why my pension papers was not resubmitted. It was only because absence of this decree of divorce.
Where does it show that you have submitted the copy of that judgment? Divorce, decree of divorce?
No, but kindly see the requirement, my lord. Page 41 of the read petition, my lord. It shows this additional requirement has to be complied with. It says next of kin, copy of marriage certificate, attested copies of voter ID, PAN, Aadhaar. These are the 3. These are I followed. Then 4 attested copies of decree of divorce. Decree of divorce.
It's okay. You produce the judgment. Do you have that?
Yes, that's a part of the record. Page 29.
Have you submitted that?
Yes.
Where does it indicate that you have not submitted? It says decree, certificate copy of decree of divorce.
Yes.
A copy of the certificate copy of the judgment has it been submitted?
Yes, my instruction is just submitted.
No, it doesn't-
Otherwise,
their affidavit doesn't indicate. It
No, no.
only says that you have not submitted. They should have said not the certificate copy of decree of divorce, decree, but the judgment, copy of the judgment.
by sanctioning this amount, the government has accepted my
No,
status.
it's okay. It's all right.
Otherwise, they wouldn't have accepted that.
It's okay. It's all right.
If required, I will submit, my lord, again.
I think it's better to submit.
No problem, no issue. What you
Because
make,
it doesn't indicate that whether you have submitted the copy, certificate copy of the.
in that case, lordship may kindly direct the respondents, my lord, APRO, my employer, to resubmit my pension papers with this judgment copy, my lord, judgment of the decree, and also direction to the AG to process it without insisting for decree of divorce.
Lordship, I'm for the appeal, Lordship. And how can we get the certificate of that divorce certificate, Lordship? The main confusion may be it's arose because the first wife is not a party to this petition, Lordship. She should have made the party
First
to the.
wife is not claiming.
Then why that confusion has arose, Lordship?
And what she's submitting is contrary to the affidavit.
But why decree has not been drawn?
Lordship, may I read?
But it's for the family court
Lordship.
to answer, madam. I can only, but I
No, I
make a
just
statement
want,
of
I'm
note
anxious to know why decree has not been drawn.
because they say it, my lord, this record could not be traced out. I make a statement on oath, my lord. Can you see page 11, my lord?
That's why the entry report in the.
Page 11 of my great petition, my lord.
Who has submitted the next of the kin certificate?
This petitioner, my lord.
No, it said if it is found that two different next of the kin certificate have been submitted. along with the
Initially, there
person-
was some confusion. That is why they insist for next of kin subsequently,
Lordship,
which I furnished. Now kindly take up their affidavit.
Lordship, may I read para 4 of this of my affidavit, Lordship?
Yes.
Page number 44, Lordship. The second part, in the middle, from the middle of the affidavit, point 4, Lordship. After death of Raman Talukdar on 25/5/2020, Ms. Ankita Talukdar, daughter of late Raman Talukdar and first wife Karta Kaur, had submitted a representation on 8/6/2020, claiming for 50% of pensionary benefits, Lordship. And she is not a party to this petition, Lordship. The daughter of the first wife. Page number 44, Lordship.
Daughter is also claiming.
Lordship. 50% of the pensionary benefit, Lordship. And if she is a party to the petition, Lordship, there will be no confusion, Lordship. The first wife and her daughter, Lordship.
APR for legal opinion. Can we read the rest? After getting legal opinion, so and so family pension case was processed in favor of so and so.
The Lordship was making a query that if any controversy was created, that's why I am answering this.
There was some controversy. Then matter was referred to legal opinion. After legal opinion,
But then first wife has never claimed.
Lordship, her daughter claimed, Lordship. Same thing only.
Can we see,
What is the relation with the daughter?
That I have to, my lord. Even otherwise, do according to the law. It has to be a portion, it should be a portion. At least process it.
They should be a party to this petition, Lordship.
Absolutely
That is their legal right, Lordship.
No, insisting of the decree of divorce may not have a bearing with the claim of the daughter. Daughter, if at all, under the law may have the different, she may have the right to claim, but then not just because whether her mother has divorced, father and mother have divorced or not, right? Authority is seeking a decree, a certificate copy of decree of divorce, right? Even if it is divorce, right?
That answer will
The
be
status of the, child will remain the same.
Yes.
No,
That cannot be changed even after divorce.
that is a different.
That's what I'm
aspect, Lordship.
saying. So you are insisting.
Not me, Lordship. The department.
Department.
AG.
AG.
Lordship.
The query came from AG. Now can you see page 37? Just for a moment, just for a second, page 37.
Yes.
By this, AG has sanctioned GPF in my favor. Same office. Page 37. Page 37, my lord. Lordship will find it was a communication made by Assistant Account Officer to SP. GPF Kindly see. The amount should be paid to the person named below in the proposal. In
You
the
submit
proposal.
the third copy of the judgment.
I will. Now. I will furnish it to the office. Let them process it. Immediately transmit this document to the office of the AG. And AC will process it, my lord. Without insisting for this decree.
Lord, I have two prayers. Subject to his, have you
Yes.
done?
Yes.
Thank you.
Please.
Lord, perhaps the reason why your lordship,
Wait for AG.
lordship,
Hmm.
your lordship will kindly take page 35, my lord. Page 35 of the writ petition. Column C, my lord. That is the reason why they are insisting on the decree of the divorce.
Which one?
Page 35, annexure F of the writ petition.
Column.
C.
Hmm.
As per so and so. The deceased has divorced his first wife so and so, wife so and so, but it is not clear to this office regarding the appointment of Srimati so and so, Aparna Talukdar, my lord, as a legal guardian of the then so and so. That's a daughter, my lord, from the first one. By the aforesaid order dated so and so, since marriage between deceased so and so and Aparna Saikia was solemnized on so and so, i.e. more than 1 year after final judgment. Further, if so and so is the legal heir of the deceased so and so, then her name should appear in the next of kin certificate along with Aparna Talukdar instead of with Miss Srimati so and so. That's the first one. As the latter was divorced by court of law, by virtue of the aforesaid court order, Srimati Kartarkar cannot be treated now as legal heir of the late so and so. However, Srimati Ankita Talukdar, being the offspring of the deceased, may be treated as legal heir, but in that case, her name should appear along with so and so in the next of kin of certificate. In any case, the factual position of the matter may kindly be clarified with supporting documents issued by the court of law. This is the reason why, perhaps, my lord. As of now, I can only say this much.
May I just respond? How that is relevant for a decree? Judgment is there. Decree will be prepared on the basis of the judgment. Now, can you see page 39? That is the next of kin.
I mean, what happened with this daughter?
Can you see
Where's
page?
the daughter?
Can you see page 40?
It's okay. Where's the daughter?
Daughter with perhaps live separately. I have to take instructions. But if she has a right, I do admit. She has the right. But can you see
do
page
one
40?
thing, you take instruction and if possible, she may file. Is she a major now?
Yes. On
You may file
21,
an
she was
affidavit,
23 years old.
Additional affidavit of what
Stating what, my lord?
You may file an affidavit agreeable to payment of that thing. He may not, she would not have any objection to that effect. Or you may plead him as a party respondent.
Perhaps that will be
My lord, can you see page 44? Next of kin is already there,
So right,
indicating her name.
that cannot be, because difficulty is there. Her father and mother got divorced.
Yes.
Maybe she is measured now. She may have something to say on it.
She was major in the year 21 itself, 23 years old, sitting there.
And hopefully she doesn't have any objection.
Even if
that would be more. I mean, it will give more clarity.
Okay, madam. If I will file it.
You
No
take
issue
and
with that.
talk to your client, take instruction, and if possible, either implead her or may file an additional affidavit stating, bringing on record what she.
Let me go back to my client.
Yes,
Let me
I
go
think
back to
it's
my
better.
client.
Let us make
Let's
it.
take instruction, madam.
Otherwise, tomorrow, even if
Let it come after 2 weeks, madam.
suppose if she says that I have not been party to the proceedings and all, suppose if any case, hopefully it should not be any problem.
Legally, I cannot deprive her. If she is
That's
legally
the-
entitled, she is
That's the
entitled.
reason tomorrow, and unless it will be, I mean, a problem for you as well as for her. So let us have more clarity on this.
Absolutely, my intention is not to deprive her.
Yes,
claim.
yes, yes.
If
I
she
understand.
legally is
No, no.
entitled, she is entitled.
But the facts situation obtained in this
I will
at this stage, at this scenario, I mean, I think we have to have more clarity.
Within a week, I will file. Within a
Yes.
week, I will file.
Had Mr. So-and-so, and also had both for so-and-so. London Standing Council.
Lordship, D. Bhattacharya, accounting engineer.
A Talukdar for common lordship.
Method, next one, method pertains to claim of pensionary benefits, right? Again, we'll say pensionary benefits.
Yes, yes.
Pensionary benefits by the petitioner. Pensionary benefits, next paragraph. It is noticed that the petitioner had married late, what is the name of that? Late Ramin Talukdar. After the divorce.
After the divorce.
After late Ramin Talukdar had divorced with the first wife. Out of the wedlock of late Ramin Talukdar and Srimati Kartar Po, a girl child was begotten, namely, what is the name? Name of the
child, my lord?
Ankita Talukdar, my lord, page 35,
Namely,
second entry, my lord. NOK, number 2, Ankita Talukdar.
namely
That's right.
Ankita, Miss Ankita Talukdar. See, it appears that she has also made an application claiming for pensionary benefits of our late father, Mr. Although the pensionary benefits in favor of the petitioner has not been computed due to non-submission of certified copy of the decree of divorce. Considering that the late Raman Talukdar, considering the daughter of late Raman Talukdar has become major and is not added as party respondent, is not added as party in this proceedings. I deem it appropriate to allow the counsel for the petitioner to take instructions and also to take instruction from the petitioner. The learned counsel for the petition may also file appropriate application. Appropriate affidavit. Clarifying the stand of the daughter of late Raman Talukdar and may so and so, if occasion arises. I'll just give like, keep it open.
Yes, yes.
Yeah. List
Lord,
after
Let it come on 7th, my lord, 7th of April, my lord, if possible.
List after 2 weeks.
May I, my lord?
Yes, 2 weeks on 07/03/04/2020.
Lord, subject to your lordship concurrence, Lord. Perhaps it will be better if
They have made a party here, my lord.
So finally, let him, suppose if they will not, suppose by now, if they don't have any, if their terms are good, if they have a, I mean, cordial relations, so why should create unnecessary?
No.
Because coming to the court, I mean, making
All
them a
right,
party,
I have nothing more.
that will do more harm than good.
Can I pray for an urgent copy of this order? Can I
Huh?
pray for an urgent copy of this order, my lord?
Why?
I'll have to send it to the court. I'll have to.
I've not directed anything to you.
No, I know, I understand.
No order has been passed against.
I understand.
Okay. Copy of this order be furnished.
All right, I have, that's all.
It will be
That's all.
approved.
That's all.
You may.
I'll get.
One
Will
minute from the-
Lordship, here I was supposed to file an affidavit.
Yes.
Yet I have not received the instruction, Lordship. I pray for another 2 weeks time, Lordship.
What is the matter?
Matters pertains to for this petitioner was initially, my lord, appointed as under the compassionate appointment quota in the year 1990, my lord, and continued as a work charged for a handyman of the road roller, my lord, till date, my lord. And he has not received the service benefits till date, my lord. That's why petitioner paid petitioner for the to absorb or absorb his service, my lord, or regular.
Your appointment is regular.
Regular, my lord.
Be happy with that. On a compassionate appointment.
Yes, my lord. Under
Be
the
happy with that. Are you claiming promotion on on compassionate ground again?
No, my lord, he is already appointed, my lord, in the against the permanent post, my lord. Against the permanent, but
So be
he is
happy with that.
now working as a work charge, my lord, without any benefit. My lord. Without any benefit, he has been working.
That's why I'm asking, is it regularly? Have you been regularly appointed?
Regularly means, my lord.
Are you working on a permanent sanction post
Yes, my lord.
on work charge basis?
Work charge basis.
What is this? Not Mr. So-and-so, learned council. On the prayer of Mr. B. Chaudhary, learned listening council. PWD. Correspondent granted for the 3 weeks time to file affidavit.
On this petition concerns two casual employees. On 2019, the finance department and the panchayat took a decision to grant financial benefit for the casual employees. The cutoff date was 1/9/2005. Now, though the list was sent, our name was left out. Most probably inadvertently thereafter.
For grant of financial benefit.
Financial benefit. The cutoff date is 1/9/2005. Now, Lordship, our names, two names were left out. Thereafter, we approached the authorities at page Lordship 31, Lordship would see. We have been verified again.
Yes, any affidavit has been filed.
My lord, initially we have received some instruction, my lord. Now just I have received some instruction. I like to file affidavit, my lord.
Why?
Within 2 weeks, my lord. Stating all the facts, my lord.
He may state the fact. You have to respond to that.
Yes, my lord. I'll file affidavit.
Because it's their declaration.
As for the notification, he is entitled because admittedly they are appointed before the cutoff date, right?
Yes, my
So
lord.
what is your
For that, my
response
lord,
to that?
verification is need, my lord, because we have to see whether his appointment is before that or not, my lord.
Heard Mr.
Lordship, that is seen at page 31 and 33.
On the prayer of Mr. So-and-so, learned council for the standing council.
Yes, my lord.
PWD.
PNRD.
PNRD. For the 2 weeks time is 3 weeks time is granted to file affidavit. Otherwise,
All right.
Yes, sir. What is this?
My lord, this was a suspension matter.
Huh?
Suspension matter, my lord. But the writ petitioner got reinstated in 16th November 23.
Hmm.
Maybe that's why the petitioner's counsel doesn't appear on the last 2-3 occasions. My lord,
What is the prayer here?
here is for my lord reinstatement.
So
It's a matter is become infructuous, my lord, long back.
he has been
Yes, my lord, he got reinstated.
reinstated.
I'm just placing the order, my lord.
We have already been granted the release, Lordship.
Okay. Heard
Yes.
Mr. So-and-so learned counsel for the petition. No, so Mr. So-and-so learned counsel with petition submits that the relief sought for in this petition has already been redressed by the authorities. Therefore, the writ petition has become infructuous. Mr. Learned counsel
Respond number 1 and 3, my lord.
has also has agreed to the same by placing the order that it's 16/11/2022, whereby the petitioner has been reinstated. The petitioner was reinstated as what?
On his earlier post, regular
He's
MR labor.
He has been reinstated. Huh?
Yes, my lord. The last paragraph, my lord.
Mr. India Babu, there is some disputes has been purchased.
I appear for respondent 6 Chairman.
29/30.
No matter the exact.
Ah,
Yes.
I think 26. And I'm appearing for 2, 3, 2, 4 and 5. Please, your lordship. There's a matter relating to regularization of service of the petitioner.
Huh.
So petitioner is working as teacher, yes, I beg your pardon. He's working as chokidar of an Interim Amity school. He can you turn up at page 35, his appointment letter.
What is this?
Thereafter, he's both got sanction. He got the approval, page 38, annexure 2.
Madam, can you be a little louder?
When you turn up at page 35 for his appointment letter, thereafter his both got approval. Annexure 2, page 38. Your lordship. Actually, he's left out of he's all the all the employees of his school were regularized, but except his service was not regularized. And lordship kindly turn up at page 125. Page 124, that fact has been already been admitted by the education department. Kindly turn up at page 125. Annexure.
What is the
Annexure, lordship, annexure 26, page 124.
what is the order dated 20/07/2021?
Oh, lordship, page 24.
24.
Page 124.
20/11/2021.
Yes.
124.
27, 2021. It's a page 124, but relevant portion is at 124. Page 124. Paragraph 1. Yes.
Services of Deva Charan Das, assistant teacher, have to be regularized against the vacant post indicated by the Assam. You have to conference with financial. Yes. Your
Yes.
case has been considered.
Yes.
By whom? This is by whom?
By the education department, but the
Special committee.
yes, but it is placed before till now.
So what happened?
Now till now, like the several I mean several direction has been given by this honorable court. First direction.
After this?
Yes, lordship. To obtain instruction, what is the status of the case? Even last occasion 28 to 2024 also, this honorable court direct them to give the obtain the instruction written what is the status of a case. But still today, neither they have submitted any affidavit.
My lord, I have received the instruction, my lord. As per my instruction directed, that's sent to the proposal before the government to regularize the service of the petitioner, my lord.
Who is the government? Who is to regularize?
My lord, Secretary, Department of Miscellaneous.
Who is appearing for him?
I am okay.
So,
Lordship may dispose of the matter directing would
to complete the process,
my lord.
huh?
would-
Within,
would
within
it-
15 days. Within 15 days.
you know, sometime more, or Lordship may allow 1 week time either so that I can filing affidavit and yes on record, my lord, this instruction.
There is already a direction. You have
Actually,
filed a
let them-
contempt petition also.
Lordship, let them file the affidavit so that.
No affidavit is required. You take instruction. There cannot be over and again. After
No,
one
it is,
after
Lordship, it is till now it is placed before the finance department. Until and unless finance department give a approval, then only this.
No, it is the job of the secretary. You obtain instruction.
My lord.
When you can finalize it. Hmm? And Miss MS so learning council for the petition. Mr.
B Talukdar.
B. Talukdar, Standing Council.
Standing Council Elementary Education.
Then Standing Council Elementary Education by placing the communication detail, a copy of the communication by the Director Elementary Education to the Secretary to the Government of Assam, Department of School Education. Dated 11/03/2025. Submits that the director has sent the matter before the government, public secretary to the Government of Assam, Department of School Education for regulation of the services. This is what, 2%.
Yes. Another
Peti-
one is,
peti- This is, we have
item
filed a
number-
separate
separate
petition.
petition is mentioned.
And in respect of the petition, in respect of the petitioners. Mr. It is noticed that this court in earlier proceedings have directed the petitioner for the directed response authorities to no, Mr. In view of the earlier orders of this court in the WPC 156 and WPC 3766 of 2020, dated 20/07/2021, and the contempt petition number 348 of 2021, dated 07/12/2023, the learned counsel for the petitioner is granted 2 weeks time to obtain instruction as to as to the time that will be taken for.
Lordship,
That would be required to complete the process of regulation of the service of the petition.
Lordship, another one is item number 30 is the
Same.
petition number 98 oblique, same matter, but 98 oblique 2024. That is, he is a teacher, he was a teacher.
Same
Same.
order.
Same.
Earlier, same order passed. Same orders have been passed in earlier.
Yes.
Earlier read petition. Yes.
98 oblique 20.
Actually. Yeah, should be this one.
Objection.
Your communication is for both the read petition.
My lord.
Yes. Should be common one. 29 and 30. Let's say 31.
Sure.
We dismiss. Sorry, sir, we'll go for trial.
Very well. Now, my lord, the next date.
Next date. Then election petition. When?
Next date, because subject to my lord, whether my lord is sitting in Itanagar.
We don't know. Till 11, I'm here.
Till 11, my lord is here. Then could it be on, my lord, my lord, 8th of 8th April. 8th April.
Very well, my lord. 8th April.
8 April. 8th April.
For
Milord.
No. They have an IA, my lord. They have an IA. So subject to my reading of the judgment, I will decide the course of action.
My lord, they may be asked. My last request was that they should file their reply.
This is made by
You butter close.
for respondent. Respondent. List the matter as agreed to by learning council of the party. List the matter on 0804/2025. We'll see along with the IA.
Yes. Lordship.
What the number of IA?
I have 54 lords. 54 of 2025.
25. We'll consider on that.
Yes.
What next?
And after reading of the judgment, if I find that, yes.
Should be given a time at least.
Yes, naturally, I'll go through it.
The approach.
Let's see, my lord. I may or I may not.
I'll do best.
Very well. Grateful, my lord.
May I please? What is this? It's item 2, my lords. I had mentioned in the morning, my lord. Item 2 may be taken up for a minute. The file of item 2, which is writ petition 1913 of 2024. 19? I can just explain in 2 minutes, my lord. Yes. Item 2's file may be kindly considered. Because this is regarding recruitment of primary teachers in government schools, my lords. And the requirement, one of the requirements is diploma in elementary education, DLED. As a one-time scheme, my lords, the government of India had permitted certain candidates diploma in what? Elementary education, DLED, DELED, diploma in elementary education. DELED, diploma in elementary education.
Yes.
As per NCT, my lords, NCTE, the National Council for Teachers Education, the prescribed limit is 24 months that any person wanting to be a teacher in the primary school needs to have 24 months of diploma. The government of India, my lords, as a one-time scheme from 2017 to 19,
permitted certain candidates to do this diploma from NIOS, National Institute of Open Schooling.
Which period?
2017 to 19. The government of India permitted certain candidates to complete this course within a period of 18 months.
Yes.
The question of whether these 24 months is equivalent to 18 months came before the Honorable Supreme Court in a judgment arising out of Uttarakhand. On 28/11/2023, the Honorable Supreme Court set aside the Uttarakhand High Court judgment saying that these courts cannot be treated equivalent for all purposes. Relying upon that judgment, my lords, I am the one who has done these 18 months course. I was considered ineligible for an advertisement issued by the government of Assam. And on 2nd January 2024, the government of Assam issued a notification saying that because there is an Honorable Supreme Court judgment, which says that both these courses are not equivalent, hence we will not consider it. There were multiple review petitions and applications filed before the Honorable Supreme Court, where government of Assam was also a party, my lords. And the Honorable Supreme Court on 10/12/24 clarified that both these courses are equivalent for all purposes. On 10/12/24, not just clarified, my lords, the Honorable Supreme Court also said that this clarification will be effected from the original date of the judgment, which is 28/11/23. That is also mentioned in the Honorable Supreme Court's order. Now, the present advertisement which is in question is of December 23, which is after the Honorable Supreme Court's clarification. And 2nd January 24 is the notification by which I have been removed. Thereafter, my lords, once the clarification came, most of the states, almost 9 states have already applied the clarification. One example I want to show where Honorable Supreme Court itself applied its own judgment. My lords would now kindly have with me for a minute those two orders. One is the clarification order. Second is how Honorable Supreme Court applied its own order by a subsequent order, saying that whoever has done 18 months diploma will be eligible to participate in the state's recruitment process. The matter came up before my lords.
Recruitment process, even if it's advertisement is prior to the judgment of
Yes,
the,
my lord.
Is it so?
Is it so? That is the point. Yes. My lords may now for a minute kindly see if my lords have item 2. The writ petition 191.
Yes, please come.
Yes, kindly come.
1913, yes.
Yes, kindly come to page 106 for a minute. That is the advertisement. I wanted to show the date, my lords. Advertisement is one page at 106. The date on top right is mentioned.
26 December 2023.
26 judgment is of 28/11/23. 28/11/23. Which is Supreme Court judgment is prior. The advertisement is later. The judgment is 1 month prior to this.
Yes, yes.
Then kindly come a page back to 105, my lords. Where is the notification which removes me? Which is the improved notification in the writ petition. Kindly have page 105. May I read, my lords?
This is under challenge.
This is under challenge. This is under challenge. The second paragraph is important. The advertisements were prepared and published in compliance with the order passed by the Honorable Supreme Court dated so-and-so 28/11/23, which is very important, in Civil Appeal so-and-so, wherein it is stated that the qualification of 18-month diploma in elementary education acquired from so-and-so is no longer a valid qualification to be eligible for fresh recruitment to the post of teachers. This is the notification under challenge. Now kindly have, lords, the clarification order, which is in my additional affidavit. In the very same volume, there is an additional affidavit that I have filed, which starts from page 336. 336, the additional affidavit starts. I'm sorry.
Come to relevant page.
Yes, I'm showing the relevant page in the additional affidavit.
Yes.
My lords, may kindly have page 347, which is the Honorable Supreme Court's order. 347 is the Honorable Supreme Court's order. And my lords would kindly mark the 5th application number, which is 42144 of 24. 42144 of 24 is the application. I'm sorry, 347. 347, and the 5th application number, which is 42144, is a application where Government of Assam respond number 4. Then kindly come to the operative part, which is at next page, 348. Para 3 and 4 are very, very important, if I may read. However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10th August 2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional revenue. Two conditions they say. 10th August 2017, I should have been in job. All the petitioners were in job. And I have completed the course from NIOS in that period. That is the condition stipulated. Fourth is very, very important. Exactly the question that fell from my lord. Needless to state that the clarification will be effective from the date of pronouncement of the judgment under review. Now, the judgment under review is dated 28/11/23. And this, my lord, is then applied. So this is passed by a bench of Justice Gawai and Justice Mishra, my lord. And then this is applied for one of the states by Honorable Supreme Court, which my lord would now see at page 350. See how the Honorable Supreme Court is applying its own order. The earlier was a different bench passed by Justice Gawai. Page 350 is another bench headed by Justice Roy. Kindly see, my lords, what has been applied in that matter. 350, the order starts. I had the fortune to assist the Honorable Supreme Court in this matter, my lords, at page 350. The relevant is at 351. And I'm seeking the exactly same order what the Honorable Supreme Court has passed for Bihar. The same very order I'm seeking. Kindly see 351 now. May I read, my lord? The the first paragraph is important. Since the Bihar Public Service Commission had issued an advertisement on 7th February 24, which is prior to clarification after the judgment, for recruitment of primary school teachers class so-and-so, the applicants seek participation in the counselling process, which is to commence from so-and-so. It is submitted that around 36,000 candidates are in fray and the present application is made on behalf of 215 aspirants. Para 3 is again very important. Miss so-and-so, learned senior counsel appearing for NCT and Mr. So-and-so appearing for NIOS support the stand. They are supporting the applicants.
Where you are reading?
I'm sorry, my lord. This is 351. 350, the order starts where the Honorable Supreme Court, via an order dated 20th December, different bench. Justice Roy applies the order passed in clarification. So 20th December is the application, my lords. And the relevant is at 351. My lords have it?
Yes, yes.
So I am reading the second paragraph, my lords, which is on top of the page. Since the Bihar Public Service Commission had issued an advertisement on 7th February 24. Here the advertisement is of December 23, after November's judgment. For recruitment of primary school teachers, the applicants seek participation in the counselling process, which is to commence from so-and-so. It is submitted that around 36,000 candidates are in the fray and present application is made on behalf of around 215 aspirants. Then para 3, they basically say NCT and NIOS is supporting my stand. Para 4, they reproduce the clarification order. So on 20th December, Honorable Supreme Court is reproducing the order to say that to avoid any confusion, we again clarify that the 18 months is equivalent. Therefore, my lords, at para 6, they say, in the meantime, we deem it appropriate to allow the participation of the applicants in the counselling process being conducted by the Bihar Public Service Commission. The outcome of the counselling process, so far as the applicants are concerned, be kept confidential. And this, my lords, is once again reiterated at page 355. So there is a series of orders where every court is saying that please, both of them are equivalent. Therefore, you cannot deny any opportunity to the applicants herein who have completed these 18-month course. And the recent one, again, my lords, is a detailed judgment by the Honorable Supreme Court in the Uttarakhand matter. 3 days back, we had argued, my lords, and a detailed judgment has come in. Can I just send out a copy?
Why don't you approach the Honorable Supreme Court?
Because the answer to that is this, my lords. In those matters, my lords, the matter was sub judice before Honorable Supreme Court. What the orders that have been passed, if my lord would see, these are orders passed in the transfer petition. The point that I'm trying to urge today, my lords, is this matter came up on 18th March and my lord were kind enough to give us a patient hearing on that day and also have directed that is the part heard matter. The state sought an adjournment that day. 2 hours later, my lords, 2 hours later, they have taken out a list of verification of the regular candidates who have done a diploma in 2 years, saying that verification has to start from yesterday for 4,100 candidates and will continue for the next 10 days. Question that I put to myself is, lords, would I not expect a fair participation in this entire process when the law is decided in my favor, when all courts are holding in my favor, and not once but repeatedly? In fact, my lords, the division bench of this honorable court has also held, I will show that order, my lords, that we are eligible and equivalent, eligible and equivalent to participate in the same very process as a regular candidate would do. So if my lord would have for a minute this recent judgment, because this was argued just 5 days back, my lord, can I just show 2 paragraphs from this? My lord would kindly have.
Are you a fresh candidate?
I am a fresh candidate. I had applied, my lord, and I'm not been called for verification.
You are not in the job.
I'm not in a job. As of now, I'm not in a job, my lord. But as per the Supreme Court order, on 10th August 2017, I was in job. I have produced proof to that effect. The Honorable Supreme Court's order requires 2 things. One, you should have been in job as on 10th August 2017 when you applied for this course. I was in job. I produced my proof to all for all these petitioners. We have produced proof. The second thing is that
Why you are not in the job now?
Maloj, I am not. Some of us may be in private jobs. Some of us, the schools have been closed. This is regarding government jobs.
Job is just it would mean the employment in the government service, not just because otherwise everyone is on the job.
Yes, Maloj. So kindly have this exact point came up before the Honorable Supreme Court. Just have one paragraph and that will be clear, Maloj. Just one paragraph, my lords would have.
This is a part-heard matter.
This is a part-heard matter, but I have this only 1 second, if you don't mind. This part-heard matter, I'm not even arguing on merit.
When it is likely to be? When it is fixed?
It is fixed for 8th of April, my lord.
8th of April.
But we have moved an IA yesterday because of this notification which has come out 2 days back after the hearing, 2 hours after the hearing.
Where is that notification?
Yes, now kindly have the IA for a minute.
So are you a fresh candidate or are you a departmental candidate?
No, there is 2 things, my lords. I have applied.
What is the advertisement is for?
The advertisement is for government teachers in the state cadre. And the post is there, the vacancy is about 5,500. And I want to be appointed as a government teacher subject to fulfillment of other eligibility criteria. There are 2 sets of people who have applied for this.
In that case, there is no question of you are in employment.
Indeed. If I have applied, I am absolutely not in a state government job as of now. Therefore, I have applied, or else what was the need to apply? So hence, my lords, the Honorable Supreme Court said that as on 10th August 2017, you should. Yes.
That is not relevant.
But I must be fair, therefore.
Whether, as per the Supreme Court, whether you are eligible or not.
Yes.
That you just show it. That's
yes.
While who are employment, who are employment.
Yes.
Whether you are that point of time you are employed or not, forget about it.
Yes. So
and
therefore,
we will have to go along with the context of the advertisement will have to.
Yes. In terms of the advertisement,
it doesn't. They didn't ask for the departmental candidate.
No. They have said
it's
that
a
you
fresh
should have.
appointment only.
I'm sorry.
Fresh appointment only.
Yes, fresh recruitment. They have said that you should have a valid diploma. I am saying my diploma is valid.
Yes.
As simple as that. That is the short point. They are, as per this notification which I read, they say my diploma is not valid, therefore I will not consider it.
Your challenge is basically page 105.
105, which is now been overturned by Honorable Supreme Court.
I'm handicapped by 2 things. One, the morning it was mentioned, I did not have my file today with me. I don't have the read petition. I have no documents with me. Secondly, the learned AG is appearing the matter. The lead matter was, if I'm not wrong, 447 of 2024 or something. 477, which went up in appeal when the interim order was rejected. Disposing of the appeal, Honorable Division Bench has given a direction that the interim order of not declaring the results of the appellants or petitioners will remain in force till the end of the litigation. That remains. That part remains for the time being. What I was suggesting is, the notification they are challenging itself says that the verification would go up till 11th of April 2025. Matter is fixed on 8th of April 2025. By that time, we are required to file our affidavit in opposition in all the matters. Anything regarding this also we will file before 8th of April 2025. Matter is taken up on 8th of April 2025. If Lordship feels that before 11th, we should also give them an opportunity of having the
verification.
They have applied. There is no difficulty on that. Lordship gives an order on 8th, we'll verify it before the 11th or we'll extend it if necessary. Today, there is no urgency that we should now publish flash notifications allowing them to come in.
No, I'm sorry.
There's nothing like that.
What the recruitment would be, the process would be.
The process is they apply.
Including your written examination.
No, there's no written examination. Especially
kindly have that notification.
What happens is, please, for a moment, Rishi, I was stopped. when I was answering? I would request an audience. Now, my lord, what happens is they apply, there is a verification of all the documents. Their results we are not supposed to declare by orders of this honorable court. So the participation in so far as their merit is being concerned, that has already been given to them for the orders of this honorable court. Let the matter come up on the 8th of April. Perhaps you can thresh out the whole matter itself.
So I'm asking what it will be consist of written exam also?
Nothing, my lord. There is no written examination. The marks obtained by them in different in all the different tests, they are taken into account. A total is done. The documents are verified. Then the final merit list is prepared. That part has not come till now. It is only the document verification we are
That's why
undertaking.
I'm asking.
My lord.
After the verification, will there be a written examination?
No. Based on the marks obtained by them in the different
Under which rule you are?
under 1977 rules.
It's only based on the marks and
documents. Nothing else. So all they have submitted their documents. Records are with us. As of today, allowing
have
them to
submitted.
Yes.
All of us have
For
given
answer
our
to
application.
Is there no, in fact, this whatever this after the submission only this notice was issued.
Yes, the notice was issued 2 days back. So therefore, what I wanted
And
to
I
make
do,
as a
I
fair
do not
sum-
even have, I do not even have.
Yes.
Notice. It is
Kindly have the IA, the notice.
2nd of January,
That is-
2024.
2nd of January is disqualifying me. Then is the Honorable Supreme Court's order. Now the notice has come up 2 days back where they are having verification for the regular candidate. That my lord will file in the IA 838 of 25, which I have filed and mentioned today, IA 838 of 2025. And the relevant page number is 35. 35.
335.
35. Only 35. Relevant page is 35. Annexure 1. If my lord would kindly have the date.
35. IA.
IA is 838 of 2025. Sorry.
836.
If item number 2, there is an IA of which is 838 of 2025.
Yes.
My lord would kindly have the date on top, which is 18th March 25.
Yes.
And this is the day when the matter was listed and they sought an adjournment. I am just reading the relevant part. It is for information to all the concerned that physical documents verification of the candidates who have successfully submitted their online application and uploaded the relevant documents in support of their candidature against the advertisement wide so-and-so, which we just read, for recruitment of post of regular teachers in so-and-so under so-and-so. Date is given from 20th March to 11th.
Okay.
So they have not included us here.
It's okay. This is first phase. This should be first phase up
Yes.
to 11th of April.
And they have not included us here. The point that I am trying to make is, my lord.
Is there any order by this court while moving the writ petition that you should also be allowed?
Yes. It is here. It is included. I have the IA.
Of the division bench laws.
Number 1913.
There is an order of this court, not just this honorable court, but the division bench also, which says that we should be included in the participation.
You read the order of.
This is your IA.
Yeah, my.
Can you just take out the other IA, 836 of 25, which is an item 1. IA 836 of 25. Please take out page 67. 67. Page 67 is an order of 9th February 24. Lord would kindly see the order of the Honorable Division Bench.
This one?
This is 9th February 24.
No, 0905/2024.
This is the one.
In item number 1.
Yes, we have just taken out, Manoj. Having heard the learned counsel for the parties for quite some time, we deem it appropriate to direct the state to provisionally allow the appellants to apply in the recruitment process initiated by advertisement dated so and so, provided that such application is filed offline before the last date, which was duly done. However, the final result of the appellant shall not be declared without leave of the court. Then please see page 86 also for a minute after this. Then that 3rd May order which my lord was referring to. First is an interim order and then the final order is 3rd May. And this was disposed of, making the interim order absolute, if I may read with my lord kind permission.
So in this, you have been only allowed to submit your application.
Indeed, my lords. And this verification is a part of that. The question that I put to myself today is
state to provisionally allow the appellant to apply in the recruitment process initiated by advertisement.
indeed, my lord. So therefore, the point that I'm trying to urge,
And
then at page, I'm sorry.
order of, it will be for the first page only.
First
So up
phase.
to April to 11.
Yes, and the answer.
Second page will be notified. You know, your name will be.
No, there is one point there, my lord. In this first phase, none of us have been included. So the only question that I put to myself is that what stops the state from including us in the verification? I'm not even asking for appointment today. The appointment, of course, will be subject.
Weapon doesn't arise.
Yes, so therefore, all
Your
that
eligibility is under
Yeah.
question, under challenge, big question.
Today, the Honorable Supreme Court has settled that. Therefore, I was showing that Uttarakhand's order.
It's okay.
So, my lords may kindly at least permit us.
We have fixed the matter on 8, we'll hear it,
My
if
lord,
not, we'll pass the
There
interim
is
order on that day.
one aspect. There is, I'm sorry. Just
If in any case,
don't keep touching me.
if this court cannot pick up the matter, then we'll pass the appropriate.
well, there is only one request, lords. 300 people per day, the verification is happening. My request is only this, kindly consider it to be, I would question myself if it was not a fair submission. The verification will take time. We are 1600 people before this honorable court. I am only urging, my lord.
This first phase is for how many people?
4100.
4,100.
4,100. The total posts are 5,500. So the total posts are 5,500. The first phase is 4,100 and none of us have been included. We are all put together 1,600. Now in this.
No, there is a provision, the interim production is already there. No final result.
The final
will not be declared.
The final result is only to us.
No, we are hearing the matter before the completion of first phase of verification on 8th.
Because what will happen is this, my lords, that this verification of 4,100 will be substantially completed by that time. If it is substantially completed, my lords, what would stop? The question that I again put to myself is, what will stop those 4,100 to come before this court and now claim parity with us? So therefore, this is the why media. Can I just put this as a suggestion? Just as a suggestion, lord. That 1,600 of us, I'm not even asking for anything more. Let us please participate in the verification.
Their verification is in phases. It's
I'm
a
sorry,
first page only. Verifications are on the first.
That is true, my lords. The verification is phase.
Starting verification of 1st of April to 11.
Kindly see, my lords, that 18th March is the order fixed. The hearing happened on that day. 2 hours later, they released this notification saying that now we'll have to.
Right.
Well, at least we may be allowed to participate in the verification.
How can we say that now?
Well, there are 2 orders of this court and.
See, once we determine, we're going to determine the matter before they complete the first page of verification.
Can I I'll just put one last point and I'll leave it for a minute. For a minute, just have this final order passed in the Uttarakhand matter. Just for a minute, not more than that. Kindly have the final order which I tendered, my lords. The controversy in my humble submission stands covered by the Honorable Supreme Court's order with respect to my eligibility. Just for a minute, just
agree. But then problem is you are only seeking today to allow them to participate, right?
In the verification. Allow me.
Just not put the methods upside down. Let them go on. It's not your scope is still there.
Because then, well, what will happen is
they are not saying that these would be the final. Applicants to be verified. They said first and second page.
Well,
for first page, they'll start from these people, applicants, the 1st to 11th of April.
Then, if that is the case, Malos, let them not have the second phase.
We'll provide that.
Yeah, let them not have the second phase of verification. At least that much of
that cannot
He will even be deprived.
Please consider me.
It's up to 11. First page will be up
No,
to
my lord,
11.
it is not. My lord,
It
just
is.
the first phase is up to 11th and the second phase they say will be
They'll
notified
notify.
as and when. So the point is this, if this first phase is completed, my lord, I'm sorry I'm pushing it because there is some point which I want to urge.
Okay.
I'm sorry, my lord.
We'll consider it. If before 8th of April, if something happens, we come back.
My lord, I'm sorry, my lord, just 30 more seconds. I won't take more than that.
Because why I'm saying, because we just cannot at this moment. Until the time, maybe we agree that the Supreme Court has decided. We agree on that.
Because then
We can take it. There's no quarrel to that.
no,
There is no dispute to that.
I bow down.
Since we'll be determining the matter on its own merit, we'll hear it.
The
That's
problem
why
is
we,
this.
there's a urgency. That's why I think we have fixed it.
Yes,
for
the problem is this. The problem is this. What we were facing as, because I have dealt with Uttarakhand, Bihar, West Bengal, all of these issues, I was fortunate enough to assist the court. The problem is this. Once a third party right is created.
Sir,
My lord.
on a lighter note, इंतजार का पल मीठा होता है, सब्र करो.
No, my lords, no one can beat on that, my lords. But okay, can I just ask as a last thing?
Yes.
At least the result of these 4100 may not be declared, my lords. If the result is also declared, then where will I be
There
there?
already.
My lords, that is for us. That is for us. That is not for the for these people, 4100. That result is only for the petitioners. That is the problem I am facing.
Yes,
The merit
not declare.
My lord, lordship will
because
have-
that they should
in
agree.
case-
No, they cannot be, I think they will not be able to declare
will
it
not
because they said verification is up to 11.
Yes,
My lords,
how can I
the
declare it
problem
before
is
it?
this. The problem is this. That on last 18th March also they said we will not do anything. 2
Not
hours
said.
later, 1 second. If
Not
you don't
said.
mind.
No,
Let me complete.
you speak a lie in the court, I
Let
will
me
have to
complete,
interfere.
sir.
On 8th, I was not
No,
in the
at
court.
least
That was
result-
why the
at
time was
least the
taken.
statement
No
was-
statement was made.
Let's do one thing.
I'm sorry.
We'll definitely consider, we're not rejecting your prayer. All right, today.
Yes.
We'll hear the matter on 8th as
Yes.
fixed.
Done.
All right, in any case, if it is not taken up for any reason, we'll take up the IA for
Done.
applicant order. All right?
Done.
Because reason is very simple. They have said clearly that there will be 2 pages. First page is from 1st April to 11 April. We'll consider that. Don't worry.
I'm sorry, I was pushing for it.
No,
I was-
it's okay.
That, but the only reason
So
was
we'll
that.
issue notice so that they can respond to it formally. All right?
Very well.
And we'll expect that
Will be
during
done,
the
ma'am.
pendency,
Will be done.
we're not passing any.
Maloj, may kindly pass it, Maloj. I respectfully urge that at least during the pendency, no step may be taken. At least that much is a fair submission I could make. No further step may be taken, Maloj. At least that much.
It's okay. We'll
Maloj, I am being
on 8
On the
and you are always liberty as today, which you have done, which you have allowed.
Maloj, my
In
lord.
any case, in between, if there's something is happened,
Maloj.
even if the result is declared, whatever is there, you come here.
Maloj, they are always
You come
there as a
back.
guardian. There is
You
no
are-
doubt
come back-
about
Come
it.
back, we'll determine.
Maloj, what happens is that we have been fighting for the
Whatever
past.
you are apprehending, if it happens,
Maloj, this,
if it comes
Maloj,
through,
this merit list was
you
also.
come back.
The matter remains
This
partnered
merit
with
list-
lordship.
This merit list was
We do
also
something, we'll be
apprehended.
facing lordship.
Therefore, if my lord would recall on that day, I requested
See,
for a status quo.
Considering the urgency of the matter, it has been kept
Lord, at
part
least
of-
that step, no step maybe. I don't think anyone would be prejudiced by that.
Cannot.
Till the next date. my lord.
Her
The
is-
verification may
her
continue.
discharge-
The verification may continue. I'm not coming in way of that, but no further step may be taken till the next date of hearing. That's all.
Okay, nothing will happen.
That at least, my lord. would record.
The government has that much of the wisdom.
My lord, if you would put it in the order, my lord, we'll at least, the fate of 1500 of us would be saved, my lord. We have been fighting
We'll
on.
consider that.
Very well.
We're not assuring that you will be allowed, but
No,
we'll
I'm not
consider-
even on that.
We'll
I'm-
consider everything, we'll determine everything on 8th of April.
Very well. Case of they shouldn't take any further step. That is my delayed. That's all.
Then after
Delayed.
delays, we will not be able to verify.
That is the only thing. Because what happens is, Malod, what is our fate left? And that is the entire argument that was taken before the Honorable Supreme Court in multiple states.
No,
That
it's okay, it's okay. We'll do it
Very well.
before they complete.
Very
All right. I heard Mr. Counsel for the applicant petitioner.
In item number.
In both, huh?
In item
IA
one, my lord.
836 and 838.
H. Burago. In item
You are
number
for
one.
838.
In item number one, my lord.
838.
Rishikesh, H.
For
Burago.
836.
836, my lord.
IA
I.
and Mr.
Mandeep Kalra,
Ah.
9838
Ah.
of 25.
applicants, with petitioners. And Mr. No, these two applications have been filed. Seeking they are applying for still the process of document verification. Which the respondent authorities has initiated by notification, notice or notification?
Notification
dated
18th March 20, no, I'm sorry, notice dated 18th March.
Notice dated 18/03/2025. Whereby the document, verification of documents of the applicants pursuant to the advertisement. Advertisement is
26th
28
December 23.
28 or
26th. 26th December 2023.
12/20/22 for filling up of
Post of primary teachers.
primary teachers in 2 pages.
Assistant teacher for lower primary school.
Assistant teacher for
teachers for both lower primary and upper primary.
lower and upper primary schools. The first phase of verification would be starting from 1st of April 2025 to 11th of April 2024. Thereafter, for the verification of documents for second phase shall be notified later. Issue notice to the respondents, Mr. Armajumdar. All of them.
Yes. One would be for NCT, my lord, Mr. Alam.
Since Mr. Armajumdar, Learned Standing Council for
Mr.
Elementary.
Department of School Education.
School Education and also entered appearance.
Mr. D. Das for CGSE. Mr. D. Das for CGSE. He was here.
You have received the copy?
Today morning.
So you don't need any extra copy.
An extra copy would be helpful, or a PDF copy would do.
We'll do it. We'll help.
Learn concept for the applicants to furnish copy, extra copies, either in hard or either by hard or soft copy. Either by soft or hard copy.
We'll do it.
During the course of the day. After getting the learned concept of the parties, learned concept of the applicants, considering that the connected with petitions, it's fixed for, are fixed for final for consideration. For final determination.
As a part of
on
8th.
08/04/2025. And also considering the verification of documents of the applicants would be taken up in 2 pages. The first page would be starting only from 1st of April to 2025 to 11th of April 2025. And after the second phase would be notified.
The first phase, 20th March, it has already started.
It said to 1st of April.
No, the first phase is 20th March 25 to 11th April 25.
Not 1st of April.
Not first.
Where it is?
My lord would see page 35 of my IA on top.
35.
Date of my IA.
18th of
date
No,
mentioned.
will be started with effect from
First of April. True.
No, the date is mentioned, my lord, for first phase,
This date when first page of physical document will be
20th
started
March.
20th March.
to 11th April. So it will be ending
On
near
11th April.
11th April.
Will be started with effect from- Okay.
The date is mentioned in bold. It starts on
Okay,
20th.
first will be with 20th of March.
Yes, it has
Yes.
Which
started.
already started.
Yes.
Up to 9. You just in that case. Huh? In place of 1st of April, it should be 22,
20th.
20 March to 29 of page 35. 29 March 2025, and the second page will be starting 1st of April to 11th of April. Huh? In both the two places you have to fill this. Huh? No, in that case, last line you have. Considering it shows April to 1st of April. Second page will be it's the 1st of April to second page, huh? For which the list of candidates will be published in the due course. Come on. I'm not review that the application be listed along with the connected with petitions. Listed. In the event, the connected with petitions are not taken up on the next date fixed, the solution. Appropriate orders will be passed. The present applications shall be considered.
So the second phase is starting from 1st of April.
Yes, yes, I've seen.
So the second phase may not start at least, or at least that much of indulgence may not make it. Because something that is already published, I understand we should not come in that phase. Second phase is yet, the list is yet to be published. 7 days matter, my lord. It was adjourned at their instance. 7 days, 8th the matter is coming. At least they can hold it till 8th. That is all that I'm saying. It's a matter of 7 days, and it was adjourned at their instance. We were ready to argue that day, we are ready to argue today also. At least that much of indulgence if my lord would get, at least no third party right should be get. That is my only grievance. At least till then. Or my lord, an alternative, if the date can be preponed from 8th to prior to 1st, even that is fine. If that is something which they would accept. Because once they publish the list, then I'll again have to come back, my lord, and trouble my lord with the mentioning and then request for 2, which my lord were kind enough to even grant it.
That will not be trouble for us. We're here for that one.
My lord, at least this much of prayer. Please do not trouble. This list may not be stayed for any reason if that is what should go on. At least the second phase should not start because we are 1600, my lord. And how many vacancies would be left? 1400. So we are already short of vacancies. The verification is going on for the second phase. Please, that much, my lord, indulgence may be kindly be granted, my lord. Especially when state of Assam was a party before the Honorable Supreme Court. 10, 12, when the matter was heard, there were parties. They should have implemented automatically the order till now. Still, they're not implementing. In all these orders that have been passed by my lord, the division bench single judge is prior to the Supreme Court order. Is prior. Post 10, 12, the sum and substance of the matter has changed with due respect. Therefore, at least that much of indulgence, my lord, we 1600 jobless people deserve, Lord.
Okay, since you have not started the second page.
Malad, just for one.
Till next day.
One thing. Per day, there will be around 300. My lordship will just
wait. However, considering that the second phase is yet to be, second phase of verification is yet to be started, and no names of the applicants have been published till the next date, that is 08/04/2024.
In that case, may I pray, madam? Matter will be taken up on Monday. Let the AG be here, madam.
Verification of the second phase may not be taken up.
My lord,
I'm so deeply grateful, my lord. So deeply
matter be
grateful.
taken up on 24th.
Balance.
My lord, let it be on 24th. My lord, the entire process from 1 to 7 will go back I'm just making a point, my lord. If in case the petitioners stand to lose out in the repetition, from 1 to 7, our entire verification goes back. That the state suffers. That 1 to 7, those 300 per day, 2100 candidates go back for nothing. They are not even before this court. They are qualified with or without a Supreme Court order. They are losing out on their verification without them being a party in this repetition.
What do you say about the Supreme Court judgment?
But on the Supreme Court judgment, the Supreme Court, the first paragraph is never referred to by the petition. I'll just make a point. First paragraph is never referred. We do not interfere in the review petition. We do not like to interfere in the review petition. What the Supreme Court in Jaibir had said, unless the recruitment rule contains a provision allowing 18 months or the NCTE declares 18 months to be equivalent to 2 years, there can be nothing which will allow 18 months diploma holders to participate afresh. When this was put forward in the review petition, the Supreme Court clarified that if there is a provision in the rule or there is a provision by the NCTE declaring a equivalence, only in such circumstances or a clause is contained in the advertisement. The Jaivir judgment was very beautifully assessed in this honorable court,
Sir,
point 477.
We are not allowing the petitioners to.
That is the whole thing.
Directing them to verify
The persons who are not before this honorable court and are having 2 years diploma, if lordship passes this order, they will not be verified from 1 to 7. 2100 people, my lord.
7 days.
No,
Monday. We'll consider.
That will go back by 7 days
Okay.
for the entire state, my lord. It could have been preponed if this was it, my lord. I would have preponed it to 24. I would have the AG here arguing the matter, my lord. It doesn't go on my shoulders, my lord. I don't even have the writ petition. I'm told today morning there is an IA. It could not have been informed to me yesterday evening. Come prepared with the file. Statement is made 18th. I took a time, my lord. I was standing in court number 1. Not because I did not want to do a matter.
So you make a mention next week if there is urgency, because second page, we're only interpret, asking them to go into second page, which is yet to be started.
Yes, ma'am.
You make a mention next week.
Yes, madam.
If you think that there is urgency.
No, Monday, whatever interim.
Yes, next.
So deeply grateful, my lord. Grateful for the patient hearing, my lord. So deeply grateful.
Yes, please.
Yes.
In this application, I am seeking lordship compensation appointment, lordship, and file an application before the Union Bank of India, lordship. Admittedly, the bank has admitted lordship, but lordship, they have filed a affidavit, lordship. Their contention is that I have not submitted some documents, lordship.
So,
Lordship, but lordship, in the same affidavit, in fact, lordship, kindly see, have a look, the document,
Yes.
page number 30, lordship.
Your lordship, I may be allowed to get some more time in this case matter because earlier one more writ petition, that is 1900 of 2019. In that connection, that the other petitioner has filed some applications, and that against whom they are taking against the contention. So right now I am not having the brief of that case, your lordship. So,
same person.
not same.
Not
person.
same.
Her, I think sister or
No,
her
lordship, what happened?
stepmother has filed some
Filed an
applications.
application.
Yes, your lordship.
So-
That was disposed of.
There's a dispose of.
Yes.
Dispose of, because earlier, lordship, what happened, before my marriage, another lady was there. She left the person with one daughter before my marriage. Then she did not come, but my husband died. That after died, lordship, she come to before the court asking pension. But this court refused and refused that it is a matter of civil court, but you have left this person, and so you can't file this petition. So I am now getting pension, and this petition has been disposed of in 2019. My landlord wants to know this file, Lordship.
Yes, that is why you
It is in my favor, Lordship, no problem, Lordship.
one sort of accommodations.
Lordship.
Not Mr. So-and-so, learn comfortable. List the matter after 2 weeks, so as.
Lordship, any, Lordship, date may be
No,
mentioned.
as per by Mr.
M. Sir.
M. Sharma, and standing council.
Yes, your lord, for Union Bank.
Union of?
Union Bank of
Union Bank of India. List this matter after 2 weeks, so as to.
Date.
Instruction.
Hello.
3 weeks.
May I please, Lordship? Lordship, we have received a copy of affidavit in opposition, Lordship, filed by the respondent number 2, Lordship. Lordship, may kindly grant 2 weeks time, Lordship. We'll file it.
On the
reply,
prayer,
Lordship.
Mr. So-and-so, learned council for the petition. The learned council for petition. List the matter after 2 weeks. Right. Unable to file affidavit in reply.
Lordship.
Obliged, Lordship.
Here I pray for some time, Lordship,
11th
for
of
filing affidavit.
that day they have submitted that they have received instruction and is supposed to file it. And today also they have not filed it. Already proposal submitted, but they had not acted on it. It is the second round of litigation, Lord.
What is your claim?
My claim is the salary for the regular earlier period, Lordship. Lordship, may kindly have the first round litigations order at page 61 and it's at 15.
No, it's okay.
Already, Lordship, we are also the part of the association.
So,
They
what
have
is your
given
instruction?
We have received instruction, Lordship.
What is there?
According to the instruction, Lordship, because their services were regularized in 2013. Initially, they were appointed under that Operation Blackboard, OBB. But their services were regularized from
After 2
2013.
weeks time.
Lordship, 2 weeks time, Lordship.
Heard Mr. So-and-so, learned council.
President, date may be fixed, Lordship. Otherwise, they are not going to.
Mr. P.N. Sharma,
Lordship.
learned.
Standing Council Elementary
Standing
Education
Council
Department.
Elementary Education. Is granted further 2 weeks time to file affidavit.
The date may be fixed.
After 2 weeks, you take the date.
Okay.
I need to be here. Yes, PWD.
Lordship, here,
affidavit.
affidavit, we had sent it for vetting, but some correction, it has come back. But
Long time back.
Yes, Lordship, come back some clarity. There was some correction that again we have sent it back. Lordship, short time.
For the petitioner on call, Mr. B. Chaudhary, learned standing as the PWD is granted further 2 weeks time to file affidavit.
Public.
Yes.
Lordship, my lord, this matter relates to appointment of in-charge principal, my lord.
In-charge principal.
Yes, my lord. In the writ petition, the petitioner has challenged the appointment of the private respondent who is a tutor and not eligible to be a in-charge principal. He was appointed. So in this writ petition, an interim order was passed whereby the order of that order was stayed, my lord. And there was a direction. Your lordship may kindly peruse the order dated 3/4/2024. Relevant portion is para 9, my lord, of that order.
2000?
It is the order passed by the Honorable Court on 3/4/2024. In the
Yes.
order sheet, my lord, your lordship may kindly see para 9. Accordingly, in view of the above, it is directed that the respondent number 5 shall not be permitted to function as the in-charge school in question. The charge of the post of the principal of the school in question shall now be held by the inspector of schools, Borpeta District Circle, until further orders from this court. It is further directed that the petitioner shall submit an application before the director of secondary school Assam highlighting her grievances, and the director of the secondary education is at liberty to take a decision in the matter with regard to the person who is not
Yes.
to be posted.
What
So
happened?
accordingly, hearing took place and an order was passed. It is page 47, my lord. This order was annexed by the respondent number 2 in his, my lord, affidavit in opposition, page 47, my lord.
Saying what?
Say in favor of the petitioner, my lord, that he is eligible. In spite of this, my lord, he has not been given the charge of in charge principal. And in fact, the respondent number 2 director has filed the, my lord, affidavit in opposition, where, my lord, it in support of the stand of the petitioner. So, my lord, my humble prayer is that since there is no dispute and it is an admitted fact that the petitioner is the only eligible candidate, so, my lord, the direction may be given to give the charge of the in-charge principal to the petitioner, my lord. It is clearly reflected in the report of the director, my lord, at page 47, my lord. Page 47. After taking the hearing of both the parties, my lord, by the director, my lord.
Who is functioning as a,
Yes, ma'am. Madam, now the director has directed the inspector of school to revisit his order, madam.
That is the improved order.
Here, madam, in the last page, page 48.
yes,
Moreover, Sri Gajendranath Kalita has been drawing regular scale of pay as postgraduate teacher since 1/1/2021, and Srimati Hiram Kalita PGT has been drawing the remuneration of tutor. And she is yet to be upgraded to the post of PGT teachers though she has completed the B.Ed course in the year of 2003 on deputation. Even
23.
if 2023 on deputation, even if now the government allows a postgraduate scale to Srimati Kolita and upgrades her to the post of PGT teacher, she will be a junior to Gajendranath Kolita, that means petitioner, present petitioner. As per the date of receiving a postgraduate scale of pay. In view of above, the order number so and so dated 12/4/2020. Yes. Now, my lord, I have to take status, present status from the inspector of school, whether charge is holding by him or charge is handed over to other
My
person.
lord, it is not held by her right now, my lord. It is taken over by the inspector, my lord, and
Earlier, academic charge was given to the respondent number 6.
which clearly court has directed, and accordingly you
Respondent number.
found that she was not eligible.
Yes.
The petitioner is the senior.
Yes.
What is the rule for appointment of?
yes, my
ambassador?
lord. Your lordship may kindly see, turn to page 20, page 19 of my writ petition, my lord. This is the provincialization order. Here the, my lord, criteria is given, my lord, page 19, my lord. Along with the list of, my lord, teachers, my lord. Para 4, Roman 3, page 19, my lord, annexure D. The teacher / tutor must acquire the requisite graduate degree in case of high school and master degree in case of higher secondary school, senior secondary school before the date of joining in the school. The date of joining must be on 31/12/2010 or prior to that date. So at the time of joining the, my lord, school, the writ petitioner had the requisite qualification to become to be appointed as a teacher, whereas the private respondent at that particular time did not have that
No, that
qualification.
has been settled by
So-
authority. There is no question
And my lord, rule 2U, my lord,
of what.
of the, my lord, Assam Educational Provincialization of Services.
No, appointment of headmaster.
Yes, my lord, in charge headmaster, and regarding the tutor, my lord, that he is not qualified.
No,
This-
qualification is not the question now. Because pursuant to the order of this court, they have decided.
They have decided the petitioner is eligible. He has
What I am
got-
asking is, what is the rules regulating the appointment or promotion of the headmaster?
Yes, he must be the
Why
postgraduate.
in charge? Why not regular
In charge,
headmaster?
because right now, till the regular headmaster, principal is, my lord, appointed, the in charge, the senior most will be the in charge principal, my
Where
lord,
is
and
the-
he has got
Where is
the,
the rule?
yes, my lord.
Rule 12 is the recruitment of principal and procedure thereof, my lord.
Headmaster or principal?
Yes, sir.
We
Principal,
are
my
concerned about principal.
Yes. Rule 14, madam. Page 35.
Inches principal.
No, principal. Principal. So, principal is rule 12, madam.
What is this in charge business?
In charge means, my lord,
Why don't you appoint them on regular basis?
till the
I've
appointment
come
of the
across,
regular basis,
this court has-
somebody has to.
This court has come across so many cases about the business of in charge principal, in charge headmaster. Why this?
So, my lord, till the appointment of the regular principal, somebody has to maintain the school regarding the environment, academic environment or financial environment. So, generally, school inspector
So
appointed.
you are not disputing.
Yes,
You are not disputing.
yes, yes. We are not
That
disputing.
he is entitled. He's entitled.
Yes, my lord, senior most. The list is also, I have annexed the list also by page 20, my lord. List
So-
of teachers.
My lord, I have to take current status regarding who is holding the post of in charge right now.
My lord,
So-
on the last of the two occasions, they have been making the same prayer, my lord, dragging the
Another
matter. my
last
lord.
Next week,
opportunity.
and last of
My
it.
lord, inspector is
Yes.
my lord, my lord.
We'll dispose it
looking
on
after
next
that.
day, whether they.
Very
come up
short
with
date may be
instruction.
given, my lord.
MSSP, what is this?
SB Chaudhary.
SB Chaudhary, London Council for the Petitioner. This on the prayer of Mr.
You, Sharma,
Yusuf London Standing Council,
standing council, yes.
Elementary,
Secondary education
Secondary
department.
Education. Is granted further 2 weeks time to obtain instructions as to whether the regarding the as to whether the petitioner has been allowed to hold the charge of in charge principal.
She may be pleased to, my lord, dispose of the matter with the direction to, my lord,
Inspector of school.
my lord.
uh,
Since it is an
Inspector of
admitted fact,
school to appoint the in charge headmaster, those person who is
who
eligible.
is eligible and the senior, he is eligible, whoever is
And
eligible.
if we
So
found
the
that
petitioner-
there is nobody is eligible, then inspector of school may hold the serve. And if there is no one is eligible, then inspector of school may hold the charge. And earlier,
have
my lord,
admitted the petitioner is
earlier, my
eligible.
lord, academic charge has been given to the respondent number 6 and not financial.
But she is tutor, she cannot hold any charge. So, my lord, since they have admitted the director, my lord, in
So
this affidavit
regarding,
also admitted
regarding
the
my lord,
petitioner is
academic charge,
eligible.
regarding academic charge, the school of inspector may revisit and hand over the charge to the petitioner, my lord.
Why
And
don't you do yourself?
my lord.
Why the direction is required?
Also, my lord, I will take instruction, my lord.
We'll see. On
Yes,
next day,
yes,
we'll
yes.
dispose of them.
On next date, maybe the, my lord, this may
Yes,
be the last
Apathy,
chance, my
yes.
lord.
In fact, there is nothing to be,
Yes,
No,
my
no,
lord.
no
The date will
instruction
be fixed.
is
Date
required
will
to
be
be
next
obtained.
Monday, my lord. Monday, my lord.
not Monday, after 2 weeks.
Not 2 weeks, next, my lord, Monday, this Monday, my lord.
Make it 3rd
Because they have already filed their affidavit.
3rd of April.
Third of-
Yes, next.
My lord, item 37 and 54 are similar matters. If it pleases my lord may take it up. 37 and 54 of the daily cause list are similar matters.
Yes.
If it pleases my lord may take the matter simultaneously.
What is the matter?
My lord, this is regarding cancellation of our affiliation of our school, my lord, by SEBA, my lord. My lord, in this case, my lord, respondent number 2, the director of secondary education, have not filed their affidavit till date. They may be allowed to.
Or Mr. So and confident.
No.
37 and 54.
54, my lord, it is in order stage. My lord, we have taken steps. I filed a dusty affidavit. My lord, may kindly peruse the flag C, my lord, in 54. Steps have been completed upon respondent file. Similar matter, similar FIR, similar company.
Here, secondary education has no role because it is a SEBA board here.
Yes, my lord. The application was cancelled by the SEBA. my lord.
So, my lord, then if pleading, if no further pleadings is there, then it may be fixed for admission hearing if it pleases my senior friend.
It's admission hearing only.
My lord.
On the prayer of Mr. So learning counsel for the petition. Both these writ petition.
Yes, my lord.
Huh?
Yes, my lord. And
Section 37 and 54.
54 steps have also been completed. It's in order stage, my lord.
We'll see that in the.
Yes.
37. List this matter after 3 weeks. List of. Mr.
DK.
DK Royal learned person. Standing counsel for SEBA.
SEBA, my lord.
What is SEBA?
My lord, a Board of Secondary Education Assam.
Oh, you
But my lord, now,
have cancelled the
my lord.
affiliation.
Yes, my lord, we have cancelled
You have the
the.
authority.
Yes, my lord.
Okay.
My lord,
Submits that he has filed the affidavit on behalf of the SEBA. Mr. MS so learned standing counsel for education.
Secondary education.
Secondary education submits it. The Department of Secondary Education has nothing to be in this, has no role in the matter. Therefore, no affidavit required to sign.
My lord, in
This
54, my
after
lord,
4 weeks.
my lord, item number 54, my lord, steps have been completed. That may kind of.
Sir, let it come its own turn.
Oh, my
Let
lord,
it come its.
my lord, fine.
Yes.
May it please, your lordship. As per last order, lordship, it was submitted his NOK lordship before the third lordship.
What's that?
Next up is submitted before the third lordship. Last occasion lordship, they submit that respondent due to non-submission of the NOK, they are unable to proceed the pen numbers.
Yes.
Lord, I am appearing on behalf of AG, my lord. My instruction is we have no role to play in this.
So who is to play? There is a direction that it should be finalized before the next day.
It is not yet finalized, lordship. In fact, the fact is the person in respect of whom pension has been claimed, lordship, he retired in the year 1996. So definitely it will take some time, lordship. We have to find out the file. Today, lordship, when I talked to the authority, they said it is under process and it will be finalized very soon, lordship.
Art Mr. So-and-so counsel to the petition who submits that as per the direction of this court. He has submitted the NOK certificate before the concerned authority. Mr. Although this court has observed that the respondent authority would finalize the pension claim of the petitioner at the earliest and preferably before the next date of listing person, comma. Mr. P. Nayak, learned standing counsel, GMC, submits the in view of the fact that who died?
Lordship.
Lordship,
father of the petitioner.
In view of the fact that the father of the petitioner had died
Retired in the year
1996. A considerable time, a reasonable time would be required for a considerable time would be required to finalize the
claim of the petitioner.
Therefore, he submits that sometime may be granted to finalize the claim and assured that as per the claim of the petitioner would be finalized within a reasonable period of time
Lordship will take up this matter after 4 weeks, Lordship. In the meantime, whatever is required to be done, it will be done.
Actually,
Three
submitting
weeks.
repetition. 2012.
3 weeks, please. Having considered the submission of learned standing counsel, this court expect that the claim of the petitioner would be finalized on or before the next letter.
Yes.
This after 3 weeks.
But that may be because pensioner benefit loss.
Give the
Any debt loss. Of less tax.
Lord, I appeared for AG in that matter, previous matter. In the previous matter, I appeared for AG.
Okay, my lord, this relates to parity of pay and rank in the clerical trade in Assam Rifles. Matter had actually twice traveled to the apex court, but because the apex court had dismissed the SLP in limine, the Assam Rifles had taken up some additional pleas, which now, my lord, recently has been again decided by a division bench of the Meghalaya High Court. And I'm told the CGSC is not there today. So in terms of the Meghalaya High Court judgment, my lord, probably it can be disposed of.
disposal.
Next week, any day, Lord, my lord. Next week, I think he'll not be there. Can we have it on 1st of April then?
And Mr. B. Patel, land counsel for the petition. Since it is, it is submitted by
I'm A. Reka on behalf of SS Roy.
Council appearing on behalf of Mr. SS Roy, learned
CGSC.
Then Mr. Roy is out of the station.
Yes, out of.
The out of the station. For which he prays that let him be adjourned 2 weeks.
Lord, can what about
Yes.
this? On 1st of April, my lord.
Yes,
Next after 2 weeks.
1st April.
obliged.
My lord, I am for the petitioner, my lord.
Yes.
Before I update the case, my lord, I had a high esteem for the academicians.
Okay.
But I'm aghast at the atrocities perpetrated on my client. Since 2010, he joined as a professor over there, as an associate professor, my lord.
After that, you let us know what is the matter is about.
Matter, my lord, that is what I'm coming to.
Yes.
I joined in the year October 2010. For 14 years, my lord, I am rotting in the same post. My lord,
Which post?
associate professor,
Okay.
in which I joined. I have already mentioned in the petition how and why my actually I have invited troubles for me. I had
Who
the
appears for the respondent?
I appear.
Have you
You know
filed the
this one number?
affidavit? Affidavit is filed. It is not required.
Record lordship.
Then
no, my lord, 8 months have passed and they have already tested my patience over. And this after 8 months, they are saying that affidavit will be filed another date. My client is suffering. He is facing actually they have advertised for the promotion to the post of HAG, Higher Academic Grade Paid Professor. So my client was deprived for the post of professor in the year 2016. And after that, he appeared, he was from backward communities, but he never took advantage in the selection list. I mean, he did not apply in the backward seat. He is actually from the backward community. Now he went to NCBC. They are, my lord, after a long time, NCBC, National Commission on Backward Communities. NCBC have somehow.
sir, it's of no use. If without the affidavit, we will grant them.
Milord, no. Milord, then kindly pass an interim order, Milord.
Saying what? Saying what?
Interim order, Milord.
For what? Interim
For releasing my, I mean, let them declare me promoted to the post of professor with effect from 2016. My lord, my juniors have long back been.
consideration has been made against you. Is the pending?
No,
The juniors
they
is party in the writ petition.
they have
He's saying about the
illegally, they have
juniors.
illegally
deprived you.
deprived illegally.
consider that.
I mean, you give
whether you have been illegally deprived or not.
Milord,
Unless,
then in that case,
have you participated in any proceedings for promotion,
I was not,
which is pending?
my name was not shortlisted. Kindly come to the page.
He's not
page
eligible
this
for
thing.
that, Lordship.
Kindly come to the page.
He's not
page
eligible for
38.
that. And what he is saying about the juniors, so that
Your-
the juniors are made part
I
of
am
the writ
eligible,
petition.
but they
Your
are,
case has been rejected.
yeah, my name was not shortlisted.
Okay.
If you kindly come to the page 38.
Okay, thank you. We'll take it another another day.
Milord,
Let them give, we'll.
And
grant
some
them
personal allegations have been made in the writ petition, Lordship. The personal allegation I will brought it in the affidavit.
we're going to file FIR against them
Yes.
for framing false documents of government under 201 of NSS.
So this,
Okay,
They have filed false documents.
heard, Mr.
Nripendra Krishna Roy, Milord.
Huh?
Nripendra Krishna Roy.
Okay,
From Kolkata, Milord, kindly, I have already come 4 or 5 times. My client has
from
actually,
where?
from Kolkata I am coming. Kolkata.
Okay, okay.
BC is possible otherwise.
Milord,
You
4
see,
or
you-
5 times after 8 months, they say we'll give us
He-
time.
He can
Then
come.
another will come, he'll say that, oh, okay, come, kindly give me time. How long? They are wasting the honorable court's precious time
How
and
time has
government
been-
money. Yeah. For 8 months, you
Service-
silent
service
all of
was
that.
otherwise- Service was otherwise not complete on the last occasion.
Who's all
They have deleted the
It's
names of the
okay.
persons. But the service is complete, Lordship, kindly see that as
Heard,
part of the
Mr. So-and-so, learned.
Nripendra Krishna Roy. Fix away.
On the prayer of Mr.
SP Chaudhary, Lordship.
S.B. Chaudhary, learned standing council. Standing council.
Yes, Lordship.
For
For the respondent number 5.
respondent 5 is granted. Further 3 weeks time to file affidavit.
But it is a very long time.
Alright, Lordship.
8 months have passed. Milord, with your kind indulgence, I object to it.
It's okay. We are.
At least 4 weeks time.
We are.
Not more than 4 weeks.
4 weeks.
For the
Yes,
timing,
but
Milord, the ongoing.
I said 3 weeks.
3 weeks time.
Oh,
yeah.
sorry, Milord, sorry.
4 weeks.
4 weeks. Then he's staying for 4 weeks. Lordship.
Sir, next time when you
Milord, I'm aghast.
Because
Just-
too much of excitement, Lord.
I
These
have
things
come back.
may happen because
No,
of
no,
too much of
not
excitement.
excitement, Milord.
next time you first call him, your colleague, as a colleague,
Yes, Milord.
that whether he has filed the affidavit or not, whether he is ready to argue the, argue the matter
Milord,
for
Milord.
final dismissal, then you come.
I'll abide by your advice,
First-
Milord. But for the timing,
You-
kindly stay
you-
the.
you
have-
don't concern about the listing of the matter. You first catch hold of him and then
Okay,
come.
okay. Yes, Milord. For the timing, Milord, kindly restrain the respondents from carrying on with HAG.
We'll see.
HAG.
Okay.
You will determine everything. Yes,
Oh,
next.
Milord.
There is no such prayer in the repetition.
Oblige, Milord.
May it please your lordship, this writ petition is filed as the petitioner's suspension period is considered as without pay. The respondent has filed affidavit in paragraph number 6. They have admitted that it should have been treated as suspension period with pay and it is under process. So my humble submission before your lordship to dispose of the writ petition with a direction to pay the seller.
Until unless they decide, how can we direct?
Now, in their affidavit, they have stated it is under process that
Other process for what?
he will be paid by passing on order to that effect.
Where it is?
Paragraph number 6 of their affidavit,
Page
page 21.
21.
And they have admitted that the suspension period should have been treated as suspension period. with pay. Para 6.
This is relative to the period of suspension. Should have been treated as suspension. Yes,
Lordship may give it direction because it is under process.
heard MS so-and-so,
That's right.
learned counsel for the petitioner. And Miss MS.
Yes, sir.
Yes, sir, Malan counsel for.
All the respondents.
What do you want? What is your claim?
The chief, Lordship, can you see the prayer portion?
Yeah.
The writ petition. That's
That's
Lord.
what I'm asking.
I am on prayer number 2, my lord.
Lordship, as a first prayer, the suspension order, it was revoked and he was
It's no
now
longer there.
reinstated. Yes.
Then
Para number 2, a writ of mandamus should not be issued directing and or commanding the respondent to pay the salary of the petition during the period
during the suspension period
suspension period.
and the annual increment which was deducted. So are you admitting this?
Lordship, regarding annual increment, that is the inquiry authority has given the allegations and all found allegations. So this is, we have not admitted. It is the inquiry committee which has given this against his petitioner.
No, no, then whether he is entitled or not.
That part they will verify. If he is entitled, definitely they will give.
No, it's not a question of that. You have deducted annual income which was deducted. You have deducted it.
Yes, yes, Lordship. But
Annual
I
And it deducted in order says in the 9/8/2024
No,
annexure 3.
Lordship, kindly paragraph 7.
Of your petition.
Affidavit, of my affidavit, page 21.
So they are not admitting this.
I'm ready to relinquish this PR
Huh?
regarding increment. Regarding increment.
You are not pressing regarding.
Not pressing.
You will say, but by filing this writ petition, the petitioner has prayed for direction to the responding authority to pay the salary of the petitioner for the period from 31/10/2021 to 31/02/2023. Within bracket, the period of suspension. Next period, the petitioner is a fourth grade employee. You are working as now?
I am
Same place.
same.
What is your post?
A
Adminis-
computer operator.
The petitioner was initially appointed as a in the group post, huh? Grade 4 post in the year 1992. In the office of the district malaria farm district. Thereafter, he has been allowed to serve as computer operator. Huh?
Yes.
Still computer operator.
Still computer.
During the course of the service, a complaint has been made against the petitioner, for which the petitioner was placed under suspension from 31/10/2022 to 13/02/2022, contemplating disciplinary proceedings. Mr. Next period. And the basis of the inquiry report. No punishment, nothing.
No, nothing, Lordship.
The petitioner has been exonerated. Mr. The petitioner has been reinstated by the order dated 14/02/2022. Mr. The MS Swenson, consent to the petition submits that although petitioner has raised certain issues, has raised different, has raised some grievances at this state, no, due to elapse of time. Due to elapse of time. No, due to certain developments. The petitioners only prayed for payment of the salary of the salary for the suspension period, i.e. 31/10/2022 to 13/02/2022. She submits that the respondent 6, i.e. additional superintendent MMTH, GMC, by filing the affidavit, has admitted that the period of suspension minor penalty has been imposed. Where is that penalty? Where is the penalty? Any penalty has been imposed,
Annual increment was deducted.
One annual increment.
not exonerated. And on the basis of inquiry that no, not exoneration. The petitioner has been imposed with a minor penalty of. Where is that penalty?
9/8/2024, Annexure 3 of writ petition,
Page
page 18.
18. On the basis of inquiry, that in between, the petitioner has been found to be guilty, and accordingly a penalty of 1 annual increment. A deduction of 1 annual increment has been with the period of suspension. Effect to period of suspension as without pay has been imposed. Then last. Miscellaneous also been admitted that since the penalty imposed is a minor penalty, the suspension period to have been spent on duty. Just accordingly, she submits that action may be issued to pay the salary of the petitioner for the period for the suspension period which effect from 31/10/2022 to 13/2/2022. MS Swenson, Learning Council, submits that since the minor penalty has been imposed, the period of suspension ought to have been considered as ought to have been treated as period spent on duty. Accordingly, therefore, she doesn't have any objection if the reversion is issued to the respondent authorities to pay the salary by 15 days period of suspension. Pay the salary of the petitioner during the period of suspension. For the period of suspension, i.e. 31/10/2022, Which we have been considering this emissions and concept for the purchase. Considering that and considering the petitioner has been imposed a minor penalty. With the deducting minor penalty of one annual of deducting one or the deduction of one annual increment from the period of suspension. It is to be considered as spent on duty as admitted by the respondent authorities, particularly the petition disposal with the direction to the respondent authorities to
Respondent number
consider
six.
the
Respondent number 6, directly.
particularly respondent number 6 to consider the claim of the petition and pay the failure for the period for the suspension period by from 31/10/2022 to 13/02/2020 in accordance with the law.
The time period may be given.
In accordance with the law, you may not entitle just because it's a minor penalty.
Problem.
It's been disposed of.
Here, there is a wrong fixation of pay, my lord.
Yes.
As regards there was an order for recovery that has been stated by this honorable court. Now, at page 27 is the order. my lord.
And the affidavit.
My lord, affidavit is required, my lord, from more.
Lordship, we have received some instructions, some more instruction.
Not Mr. So-and-so. Mr. On the prayer of Mr.
You question on behalf of DP Bora.
Learned counsel for the petitioner. List this matter occur 3 weeks.
My lord, here
So as to
affidavit
enable
from
the respondents to file their affidavit.
affidavit from
next.
affidavit from accountant general will be necessary, my lord.
Accountant general.
My lord has fixed in the date.
After 3 weeks.
May I appeal, your lordship. In 46, my lord, I am respondent number 5,
Yeah.
and I filed my affidavit, my lord.
Your file.
Yes, affidavit in opposition, my lord. My stand is, my lord, I am the senior most officer. So far, my lord, seniority list is concerned, and I am also only entitled to hold the charge of principal and hold the charge of
Your appointment
academic
is-
exams.
Your appointment of in charge principal is
Yes,
under
lordship.
challenge.
Yes, lordship.
Actually, not, my lord, seniority.
Seniority, my lord, on the basis of I have my petition, my lord, item number 47, and so far 46 is concerned, my lord, I am respondent number 5, my lord. And I filed petition affidavit, my lord, my contention, my lord, paragraph 5 and 4, my lord.
You are in item 46, you are in petition.
Item, lordship, for item 46, I am respondent number 5.
Yeah.
I filed affidavit, my lord,
In item 47, you are,
petitioner, my lord,
okay.
lordship.
What is your case?
My case is, my lord, so far seniority list is concerned, I am senior most officer and having all the requisite qualification.
So you have been deprived.
Deprived, and I am,
Then what is his case?
he is far junior, my lord.
46.
He is junior.
Okay, but what is your case? Item
Now, my lord,
46. You are in
whatever, my lord.
petition and in item 46.
Yes, my lord, I am
So,
petitioner in the item
what is your
46, my lord.
case?
Here, my lord, the petitioner, my lord, in item 46, my lord, here, he was appointed as assistant teacher on 6/12.
Pleadings completed. Pleadings are complete.
No, my lord, in the item 46, education department has not filed their academic matter.
Not Mr. So-and-so, learned counsel for the prayer. Record only a name, huh?
And in the
On
mean,
prayer of Mr. MS, you want to file affidavit
Yes, the lordship.
as per our learned standing council, BTC.
No,
Oh,
lordship.
What?
Secondary education.
Secondary, sorry, secondary education. list this matter after 4 weeks, so as to enable her to file affidavit.
And in the meantime, my lord, no order is to be passed by the department, my lord.
How can?
Lordship, because in the meantime, my lord, in arbitrary another order passed in
We'll
favor
see.
of the petitioner.
Who consider,
In favor of the petitioner, item number 46.
who is holding the in charge?
Lordship.
Who is holding the in charge as president?
Nobody.
No.
Yes.
No. Sanjay Kumar Talukdar already order passed recently.
Thank you.
This recent order passed
I
already.
will consider.
Hello, item 40th, my lord, I am appearing.
Huh?
Item 40th, my lord, I am appearing for the Assam State School Irrigation Board, my lord.
Yes.
We need some time, my lord, to file our.
Also,
Lordship, there is just one small prayer in this matter. This petitioner is a student, and the prayer in the writ petition is for regularization of, he was not granted proper marks and proper procedure. He's a mentally disabled person. He was, during the examination, the extra time which is supposed to be allotted, in spite of request, he was not granted. And in the maths paper, there were questions which are out of syllabus. In the CE exam for engineering admission, the common entrance exam, he has cleared it, but he could not get the admission only because of lack of 6 marks, lordship. 6 marks. So in the meantime, during the pendency of the writ petition, provisional admission may be granted to him in any one of the institutes to have been arrayed as respondent number 4 and 5. Because his year will get spoiled. He will have to
It will be
appear.
difficult, madam.
Lordship, he will not be permitted to appear for CE again next year.
No, if you are not qualified even for a half mark,
Lordship,
then we direct them to.
no, Lordship, he was not. The questions I have categorically mentioned that which were the questions which were out of syllabus. The RTI also provides that yes, these were the questions which were out of syllabus, and because of that, he is lacking in 6 marks.
Yes.
My lord, short time, my lord. I will.
Lordship, this matter I had moved in the month of December. From 4th December, now is March, Lordship. Somehow it has come in the list. Somehow. After making several applications before the registry, this matter has been listed.
What order we can pass in this?
Lordship,
is
just
this?
provisional admission in one of the engineering colleges.
What is your prayer?
Lordship,
how can we enhance the marks of the petition in mathematics? No.
Yes, my lord.
Lordship,
Enhancing of marks only.
How can we enhance? How
Lordship,
can we
because-
direct them to
because
enhance?
the questions were out of syllabus, Lordship. Questions were out of syllabus.
Maybe.
Lordship, this entire year will get spoiled. In 2023 also, he could not appear his HS exam due to various surgeries. In 24, he has appeared as a private candidate.
Where with you on humanitarian angle, on humanitarian consideration. But legally, how can we direct them to enhance their marks?
Lordship, because the questions were absolutely out of syllabus.
On
He
human,
has-
madam,
has
on
full-
human angle, we're definitely fully with you.
All of us.
But legally,
Lordship,
how can we
it is the
direct?
fault, it is
Sorry.
the fault of the board. It is the fault of the board that the questions have come out of
We'll
syllabus.
see.
Yes, ma'am.
And MS Swenson, learned counsel.
Dr. P. Agarwal.
DK
Mr.
Roy,
DK Roy,
1 and 2, my lord.
learned standing counsel and so, learned counsel for the respondents
3, 7, 6, 3, 4, 5.
are granted 2 weeks time to file affidavit in
Yes.
affidavit in opposition.
Lordship, of fixed date may be given.
This very difficult. Give
Not
the
right.
date, but then no repetition is difficult.
Lordship, I understand. I'll try my best to satisfy this honorable court, but at least I'll give it a try. Lordship, your lordship, I directed to give a date. Obliged.
May I please, your lordship.
Yes.
My lord, petitioners participated in the, my lord, recruitment process in the Central Armed Police Forces, my lord.
Yes.
They have got the cut-off mark, but the result of the petitioners have been kept withheld due to mismatch of biometric data, my lord. In the similar circumstances, my lord, Honorable Kerala High Court passed an order, my lord, directing the authorities to appoint them, and thereafter verification was done. And in the meantime, petitioner will furnish the bond, my lord, that if the, my lord, petitioner found, my lord, guilty, my lord, they will refund all the, my lord, benefits. The judgment, my lord, kindly see Phase
Lordship, that was not considered on the very first date. We have now those years are with different CAPFs, and we have to verify those years, Lordship, because of biometrics mismatch, Lordship. One had already disqualified for 2 years, but other 17 are left, Lordship. So we need at least 4 weeks time.
Not 4 weeks, 3 weeks. Heard
Lord.
Mr. So-and-so learned council to be. MS so-and-so, one person.
Yes, sir.
For
And for all the
all
respondents.
the rest. Is granted for the 3 weeks time to. You want to complete the process?
Now that those years are with different CAPFs, that has to be sent to CRPF, who are the nodal agency. Then it will be
File
verified.
affidavit to file affidavit in opposition. In the meantime, the process of verification of
They are those years, original
years.
records.
may be completed.
My lord.
Within 3 weeks, you complete.
50 also similar matter, my lord, but it is requirement for the 2022, my lord. Result was declared on 28-23, my lord.
Same order.
Same order, Lordship. I require time, 3 weeks time to file affidavit.
You complete the process into verification.
Yes, under process, verification process is going on and.
Same order,
Yes, Lordship.
3 weeks.
3 weeks.
And so that it is completed.
Yes, Lordship.
This way, that way.
Obliged.
Lordship, here in this case, Lordship, I seek some time, Lordship, 3 weeks at least, Lordship, to obtain the instruction, Lordship.
What is the matter?
Yes, Lordship, it is departmental proceedings. It was removed, no?
I was dismissed from
Yes,
service, sir.
dismissed.
Okay. You file the affidavit,
Lordship,
file affidavit
Yes.
and place the record.
Lordship, first, I will file
Dismissal.
the affidavit.
Yes, sir.
Dismissed from
Dismissed.
service. Or Mr. So-and-so. Mr. J.K. Goswami, learned additional senior government advocate, is granted for the 3 weeks time to file affidavit and to produce.
Lordship,
place the-
first affidavit, Lordship.
No, if you file the affidavit and then and to produce the records.
Deeply obliged, Lordship.
Your affidavit will be based on record only.
Yes, Lordship, but so far,
You call for the records
so
and prepare the affidavit.
no, Lordship,
and place it.
they will submit us the Pedavas comment, Lordship, and
It's okay.
for that, that's deeply obliged.
Please, Lord. My
Yes.
lord, today is the date fixed for consideration of the interim order, my lord.
What
Lordship,
interim order?
Lordship, can you have a look the last order, my lord? Today is the otherwise date fixed for the consideration of the interim, my lord. On the last date, time was sought for by them to take the instruction.
Yes, my lord, I have received the instruction here, my lord.
Yeah, my lord. I'll just say, my lord, yeah, my lord, we have challenged and impugned inquiry report, my lord. Because, my lord, the trial court, no charge sheet, nothing has been laid, my lord. Even though, my lord, inquiry officer of his own motion laid, my lord. Own motion laid, my lord.
Yes. What is your?
My lord, yes.
My lord,
Before
one, my
coming to
lord,
that, my
criminal
lord, I'll
case
just
was
take 1
instructed
minute
against
time,
the-
my lord, lordship. Lordship, kindly have a look the inquiry report, my.
Just wait, what instruction he has?
Yes, my lord. This is my instruction.
What is your instruction?
Yes,
Tell
ma'am.
us.
My lord, he was instituted, he was my lord, arrested against a corruption case, my lord. And thereafter, my lord, the petitioner was suspended. And my lord, the departmental proceedings was initiated against him, my lord. And thereafter, inquiry committee also constituted an inquiry report also sent to him to his reply. But my lord, he has not filed any reply at that time. So, my lord, thereafter, my lord, the office by order dated so 16/9/2024 accorded sanction under section 19 of Prevention and Corruption Act 1988. And he was reinstated. He was reinstated, my lord, as per Honorable High Court order dated 21/1/2025. In so and so writ petition, the Babul Chaudhary was reinstated in his substantive post and posted as a subject teacher in Kawemari High School, ASS School, Nagaon. Head office ordered number so and so.
My lord will see, my lord, page 79.
Let's see, you just tell us what is your ground.
My ground is that, my lord, yes, my
Departmental
lord, there is a
procedure.
similar case has been already decided by the honorable court, my lord, that I'll supply the copy, my lord. Once, my lord, the charge sheet has not been filed by the, before the trial court, my lord, the inquiry officer is not a judicial officer nor a judge also. He said, my lord, lordship, kindly have a look, page 79, small paragraph. May I read, my lord? May I read, my lord? After careful.
Are you saying that there cannot be a simultaneous proceedings?
There is another aspect is there, simultaneous cannot be.
Huh?
Basing on the same subject, one aspect.
We'll
No, my
consider
lord,
that.
I'm coming, my
We'll
lord.
consider that.
Lordship, I'll get retired on 31st March, my lord.
For the, huh?
I'll get retired on 31st March.
We'll see.
My lord, lordship, if your lordship is
No,
not,
how can you stop like that?
lordship, I'll come
Department
to that,
proceeding,
my
we
lord.
just
Lordship,
cannot
kindly
stop it.
allow me 1 minute time, my lord.
What in 1 minute? You are saying the why? Are you saying that there cannot be simultaneous proceedings?
I'm not on
Criminal
to
as well as
simultaneous
department.
proceeding. I'm on to that, my lord. Once the charge sheet has not been laid, the inquiry officer cannot hold that I am the guilty prima facie offense.
Where it is?
That page 79, my lord.
No, in the process, let there be a you will be given the opportunity to. Have you been furnished with the inquiry report?
No, my lord, I have not been asked.
We'll ask them to furnish.
My lord will
This
say,
is
my lord. My
midway.
lord will say, my lord. What is
No,
my,
no, that's not.
my
Because
case
the
is,
inquiry report, the disciplinary authority may not agree to that also. He may not accept the inquiry report. It's a,
But-
in between. We cannot just enter in between.
my lord, even though inquiry reporter cannot, inquiry officer cannot say, my lord, that I'm a prima facie guilty until and unless it is been filed charge sheet.
No, sorry. I'm
There
not-
is a judgment
I'm not
also, my
pursuing. Well, judgment, keep it yourself. We'll hear you at the, consider at the time of
lordship.
final hearing.
Lordship, I'll get retired, my lord. Lordship, fix the matter any day next week, my lord.
Heard Mr. J. Burua, learning counsel for the petition.
I am Mr. U. Sharma.
Mr. U. Sharma.
all
learned
the
counsel for the
respondents.
petitioner. Learned standing counsel.
For secondary education department, all the respondent, ma'am.
Ah,
All the respondents, my lord, secondary education department.
secondary education department. Praise for and is granted 3 weeks time to.
My lord, by this time I'll get retired.
No, we cannot help it out.
Lordship, fix the matter on 25th. Lordship, get the time. Lordship, hear it. Otherwise, Lordship, fix the matter some other day. Lordship, fix the matter on 25th, my lord.
Why?
Because, my lord,
See, you just cannot. Are you? That's why I'm asking. Can you say that there cannot be a simultaneous proceedings?
my lord. Charge sheet
You
has
saw that. I'll just state the proceedings. You saw the judgment.
judgment, my lord. Right this moment, I do not have,
Then-
my lord. Another judgment is there, my lord.
Rather, there's no law or there's nothing. No proposition of law that the both cannot go together.
My lord.
Rather, it says it can go together.
It can go together, my lord. But until and unless charge sheet has been laid down,
No, sorry.
there is a similar
Sorry.
case has been decided by this our court, my lord.
You saw the Supreme Court judgment.
My lord, if the facts and circumstances are different, my lord.
It's always
it can go.
there.
But same subject matter, same relying on the same.
Same subject matter it can go. Unless it is a similar set of facts. and
Yes, similar stance of facts, my lord.
Not convinced. Next, after 3 weeks.
Lordship, fix the date, my lord.
I'm
Anyway,
rejecting your into prayer, huh?
today is the fix for the.
So I'll reject your into.
No, my lord, that cannot be rejected, my lord. Lordship have to hear me, then any day.
Prima facie, I'm not convinced.
Lordship, prima facie is why I am saying, my lord, until and unless the criminal court do not receive any charge sheet against me, the inquiry officer cannot hold that I am a prima facie offender.
Do you
That
know,
is the judgment of our high court.
you must be aware, the inquiry report is not the ultimate order.
My lord,
the
they are
requirement proceedings.
proceeding on that has to be stated.
The inquiry report will be furnished to you.
My lord-
You will be given a time to respond to, file a representation. And just because the inquiry officer found the charges against to be proved, it doesn't mean that the disciplinary authority will.
That
agree to
observation be given
There
if
is no
interim.
automatic agreement or that is not acceptance of the inquiry.
My lord,
It's a
their
process of the-
intention was to dismiss me from the service. That's all, ma'am.
What to do?
At least lordship fix
Law
the matter.
permits that they can go. They can initiate the department's proceedings simultaneously, even if vis-a-vis the criminal proceeding.
My lord, that is the second aspect. First aspect is that, my lord, there is a
That
judgment.
is the first and last, only and one aspect.
My lord, anyway, my lord, I'm keeping aside those.
Okay, thank
Now-
you. Next. Or else I'm not satisfied, I'll reject your input.
My lord, that cannot be rejected. My lord, lordship fix the matter. I'll make
Okay.
mention before any other bench. If your lordship is not.
No,
That
no,
is, sir.
I'm not mentioning it. I'll fix it
Yes, yes,
after
lordship.
3 weeks. Let it come up before this court.
Yes, yes, lordship
So
can
please,
keep the
I'm-
matter as a part. That also I'm agree. It will be definitely before your lordship. Lordship keep the matter as a part.
Sir, not that somersault. You want sometime you say it should be fixed in some other court.
No, my lord, I said if your lordship is not hearing today, I'll make a prayer before other court, my lord. If your lordship is sitting, obviously it will come to your lordship.
My lord, on the
Make it 2 weeks. Hey, mister, you have received the instruction,
yes, ma'am.
2 weeks.
So date may be fixed, my lord. Any day your date after 2 weeks.
No, no, 2 weeks.
My lord.
You get the date from the registry.
We have to file our affidavit on the basis of the instruction.
That's why 2 weeks.
Yes, yes.
I've said earlier
Yes,
it was
yes,
3
2
weeks.
weeks.
Make it 2 weeks. Man is retiring,
Yes.
although he may not have the case.
Yes.
Lordship, matter relates to non-payment of retirees and
Yes.
family pension, Lordship.
What is to be done today?
Lordship, interim prayer may consider, Lordship,
What is
retiree,
your interim prayer?
Lordship, kindly have a look at page 8 and 9. Retirement benefit, Lordship. That 50%.
Why you have not been given?
Lordship,
Why you have not been given?
it was not known to the petitioner, Lordship, why he has served for a period of 39 years. And while he was in service, he expired, Lordship.
You retired age?
Lordship,
Retired age?
he expired, Lordship, in the year 2013.
Okay.
Sir, 2013 to till date, Lordship, it was not paid.
In what capacity the father was working? Assistant teacher. Yes. Elementary. Who? Who is the authority? Who is the authority? 52. No, no.
60, Lordship, item.
Huh?
Item number 60.
60.
Yes.
Huh? Item
60,
supplementary.
supplement.
Yes, affidavit. Not Mr. So-and-so, learned counsel for the petitioner, Mr. N.G. Khatide, learned standing counsel. Elementary.
Elementary.
Granted for the 2 weeks time to. 3 weeks time to file affidavit. List after 3 weeks for admission hearing.
Lordship, a date maybe.
Give
Pension
that
matter,
after
Lordship.
3 weeks.
Public.
But 18 matter was taken up, but the government advocate paid for some time accommodation. That is why I lost it, fix it today, madam.
But the problem is,
No, it
can you
will,
complete?
it won't take much time, madam. I'll take hardly 10 minutes.
My lord, your lordship may just see, my lord. Here, one advertisement has been issued
For appointment of, yes, post of.
We'll take it up on Tuesday,
Tuesday.
next Tuesday, next. 25.
Instead of 25, my lord, 25, I'll be in the midst of a matter which may take whole day. So, my lord, can it be on 26th?
27.
No, it should be on, hearing day.
Thursday.
Thursday,
It's,
yes.
it's better to be on hearing day.
Yes, right, right.
Thursday, your lord.
Possible.
27.
27 of.
27.
My lord, with a liberty, if it is come below the list, we can request your
What is the
lordship.
urgency? Okay, what is the urgency?
No, urgency, my lord, this
It
post,
stays there.
no, it stays there. And in the post of Manipuri language, the assistant professor, it has been vacant for last 3 years because of the stay order.
You are for
I'm for the college, my lord.
college.
Yes.
And I am for the selected candidate.
Okay, selected candidate.
The school, ultimately, my lord, the college is suffering.
But that's why we're fixing on Thursday.
Yes, yes, definitely.
Heard Mr. G.N. Sahewal, Senior Assistant by
HK Sharma.
and Mr. S. Lanka, Senior Counsel, Assistant by.
Answer the yellow.
And
This was for respondent
number
number.
respondent and as agreed to by the London Council to the parties list is matter on 27.
Interim may continue, my lord.
Interim order for some.
Okay.
But you participated in the
Yes,
interview.
yes, my lord, everything, my lord. Yes.
What is your ground?
My ground is this, my
What
lord.
is your
There are
stand?
2 points, my lord.
What is your stand?
Our stand, my lord, he could not get the marks.
Okay,
Now, therefore, he has been ousted.
okay.
Now, the law is very clear in the subject, my lord. So he's,
What premature?
The director has not taken call.
Huh?
Director has not taken call.
No, once
No.
he has not been, I mean, he or she has not been rejected, found to be disqualified, he went the
he is
question.
disqualified, my lord. He is not in the selection list. He is ousted.
He has a right, what is the, why was saying?
Difference is 0.4 marks, my lord. 0.4 marks. I shall 0 0.04 marks.
Your lordship, here
I
it is
shall place,
it's
my
a
lord,
matter of-
how, my lord,
Okay.
a matter of 10 minutes, if you can explain,
Thursday.
I will take 2 minutes to dismiss it, my lord.
dismiss or allow.
Your case.
Affidavit is yet not filed.
Huh?
Affidavit not filed by the respondent.
for? Your petitioner,
Lordship.
for what? This is for what?
It is for lordship non-payment of area salary, lordship.
Yes. Which department?
Higher education.
Higher education. Heard Mr. So-and-so learning council for education. No repairs for the respondents. Or list after 3 weeks. In the meantime, the respondents may file their affidavit.
Lordship, a date.
3 weeks, we'll see.
Oh, let's.
You are going back again.
May I please your lordship? Lord, in this matter, my lord, regarding seniority and promotion, after the interim order being passed, my lord, the authority has already promoted me, my lord. And the contestant is not contesting, my lord. There is an order regarding service or not is complete, my lord. And I am going to retire on 31st, my lord. Only this must remain, my lord. Part of my increment was not increased.
Why is it listed today?
My lord, listed, my lord, maybe disposed of a small order, my lord. Nothing, the main part is already over.
Which for
It is
respondent?
sharp, my lord. PWD, my lord.
What is your grievance?
Events is that, my lord. Kindly, I have filed every week today, my lord. Kindly take it.
No, what is your grievance? First,
Grievance.
tell us.
Grievance, my lord, is that my lord, did an impugn order was passed. Kindly turn to my lord page, last page of the petition, my lord.
No, what is this?
Yes, my lord. Last page of the petition. My lord, my junior is promoted in place of me, my lord, to the post of head assistant. Kindly turn to page 32, my lord. The last annex are 10, my lord. And your
Just head assistant.
yes, my lord.
Annex 26.
My lord, another 10, my lord. And
Page
Page 32, my lord, kindly have the last order, my lord, kindly see the last order, my lord. The order, it made it clear to your lordship.
Yes. What is the last order?
Kindly see, my lord, the dated 28/4/22, my lord.
There is not the last order.
My lord, 28/4/22, my lord.
There is second last order. Yes.
Har Mr. So-and-so issue notice so-and-so steps and so-and-so, my lord. Paragraph 5, my lord. The petitioner was promoted as a senior assistant in the office of the executive engineer PWD, Karimganj, not Karimganj, South and Badarpur, so-and-so, Assam on 1796. The respondent number 6, Subhashish Pal. He is the respondent, my lord, present respondent. Private respondent was promoted as a senior assistant on 6/8/18. Admittedly, going by the respective dates of the promotion, the petitioner is senior to the respondent number 6 as a senior assistant in the office. By the order impugned, dated 28/2/22, the executive engineer allowed the respondent number 6 to the in charge head assistant of the office, although temporarily ignoring the claim of the petitioner for being the in charge on the basis of his seniority as a senior assistant in his office. Considering the prima facie case being made out, and in view of the balance of convenience and irreparable loss to the petitioner may suffer, the order dated 28/2/22, that is my impugned order, my lord, the promotion, allowing the respondent number 6, Subhashish Pal,
Yes.
my lord. Then, my lord, can
So-
my lord, can lead to the next page, my lord.
Next, don't forget about next page. Tell us what
Yes,
thereafter what happened.
Then, my lord, that did not comply with it. The order is state.
Ah.
And they did not comply. Then I came up with a contempt case, my lord. On the day it came up for hearing for contempt, then I was allowed to join. I was promoted. I was promoted on that day itself, my lord. It is recorded by the court. Then, my lord, what happened? While the engineer promoted me, he said only on temporary basis.
So
Then, my lord, thereafter, after on 23, 2003 and 2023, I was formally and finally promoted. So, because of being selected by the state board, by the state selection board, I am the senior most. I am given the page 51, my lord, today's affidavit. Then, my lord, what
matter
happened?
ends there.
Yes, my lord.
Your challenge was to the in charge allowing given on in charge to the respondent number 6.
Yes.
Now you have been given regular promotion.
Yes, my lord.
Matter ends
But,
there.
yes,
Close.
but remain things remain.
We are beating around bush.
No, my lord. That the main thing is remain.
What main thing?
I am one thing is remain, my lord. I am kindly see the order kind of this. Then you will also understand there, my lord. Page 51, my lord. Kindly see, my lord. Of the affidavit, my lord. Kindly have a look.
Tell us first, and then we'll
Yes,
look
my
into.
My lord, what the order is passed? See, Ashish Dev, senior
Yeah.
assistant in division, is promoted to the post of so and so temporarily. It is not, my lord, confirmed till now. Because I have
See, we are not. That is a press cause of action. Your challenge was to the appointment of the respondent number 6 as in charge.
My lord.
Right?
Yes.
That has been done away.
My
Matter
lord.
ends there.
My lord.
If now you have been promoted, not promoted, that was a press cause of action.
No, my lord, no, my lord, promoted. Only this part remain, my lord. That it is not my post is not confirmed, my lord. Only a single word is required, my lord, to be confirmed the order. Only this much, my lord, and the increment to be increased only this month. I am going to, my lord, retire on 31st, my lord. This 31st March, my lord.
Sorry.
For this part, I cannot again hesitate to come with the case, my lord, because
It's up to you if you don't come.
my lord, this is part of the same cause of action, my lord.
No.
My consequent part of same action, my lord.
Impugned office order dated 20, this is what? 28th February 2022. Appointing respondent in charge head assistant.
Yes, my lord.
Have you been given the?
Yes, my lord. I not only in charge, my lord, I wanted to be regularly appointed as a, because it was due to me, my lord.
Where is your prayer? Where is your prayer?
My lord, only for this small part, my lord, the same cause of action, my lord, from the coming out of the, my lord, page 17, my lord, and 18, my lord.
To promote the petitioner to
Yes,
the
my lord.
post of head assistant.
My lord. They have promoted, my lord.
Where is this? Where is your IA?
My lord, affidavit, my lord. It is in the file, my lord. Affidavit, annex to take.
affidavit?
Yes, my lord. Affidavit to take file.
Additional affidavit.
Additional affidavit, yes.
Is it here?
Yes, my lord. It has, my lord.
Order dated?
My lord, kindly see the order, page 51, order dated 28/3/2023.
51.
NXRD page 51, my lord. Today it is annexed in the morning, your lord. Your lordship ordered, my lord. allowed me to.
Where is it? It will-
Page 51, my lord, order dated 28/3/2023, my lord.
Hmm.
In pursuance of the Deputy Secretary to the Government of Assam PWD Establishment Confidential Cell disposed notification number so and so dated 27/3/23. And as per recommendation of the Selection Board, C Ashish Dev, Senior Assistant of this division, is hereby temporarily promoted. Only this, madam. I should have ought to have been confirmed, madam, because every service is confirmed like part of done, but something is they kept hanging for me. I am suffering for this, my lord. This much image. Nobody is contesting, my lord. He is not contesting the no
You
secret
have been
response.
promoted
Yes,
on the recommendation of the selection board.
yes, my lord. Yes, but
What more you want?
no, my lord. This is temporary. It cannot
With
be, my
the
lord.
scale of pay rupees so and so, this is the scale pay
My lord,
you
no.
are entitled.
My lord, yes, my lord. Yeah, that is everything is correct, my lord. Only the temporary should be confirmed. This is remain, this is kept pending because the case is pending. They are not working on it. Only the temporary confirmation order should be passed, my lord.
Sir,
That is on.
You are misconceived.
My lord, kindly see the order.
It's a
My lord,
regular promotion.
my lord, kindly see there are other promoting orders in the same. In my case only, there are confirmation order past temporarily promoted, then confirmation past promoted, then confirmation. That is, my lord. So, how, my lord, it is done in 2023, my lord. Because the case is pending, the respondents are coming and not attending the court. Ultimately, I have to take steps again and again. Then it is deemed to be served, my lord. He is not coming. So I cannot go for another order for my lord. This my prayer was for promotion to the post of head assistant.
Accordingly, you have been promoted.
No, my lord, not only done, my lord, not completed. It is halfway, my lord. Temporary what is used, my lord. Because
Mr. So and so, learned counsel for the petitioner by Mr.
for PWD also.
Is he not misconceived?
Yes, Lordship, because here the prayer was
Just
for,
because the word used is temporarily.
and Lordship, if he
It's
has got,
always like that only.
My lord, my prayer was to be promoted
It
to
will
the
never say that you are permanently and regularly
No, my lord.
promoted.
No, my lord, confirmation is there, required, my lord. Kindly see the order, orders next, my lord. Kindly see,
Lordship,
my lord.
first of all, temporary promotion, thereafter confirmation. If he has got any grievance, he can file a represent because it's a separate cause of action. Lordship may direct for disposal before his retirement.
My lord, kindly turn to Pennexa 2, my lord. Kindly see. There is a like
So
similar
it's a
order.
learned counsel by the petitioner.
My lord, kindly
By filing this writ petition,
2 and
the
4, my lord.
petitioner has challenged the impugn order. They challenge the appointment of respondent number 6. Kya naam hai? What's the name of the respondent? number
Ashish Pal, my lord.
Ashish Pal. Where is that impugn order?
Page 39.
Huh?
39, Lordship. 38, Lordship. Type copy is at page
Whereby
37.
challenge the assail the order office order dated. What is the order of
28 February 2022, my lord.
28/02/2022, whereby one series Subhashish for senior assistant
Junior to petitioner.
has been directed to take over the charge of head assistant temporarily on the ground that the case of the petitioner, the petitioner has been ignored, despite he being the senior to the said,
Senior most, my lord. Senior most.
despite he being the senior most among the senior assistant.
Yes.
Stuff. During the pendency of the writ petition, as placed by the petitioner, which IA, what is the IA?
I know, my lord. Additional affidavit, my lord.
Hmm?
Additional affidavit.
By way of additional affidavit, has placed the copy of the order, has brought on record the copy of the order dated, office order dated 28/03/2023. Is it so?
Yes, my lord.
Whereby the petitioner has been promoted on the recommended, as per the recommendation of the selection board to the post of senior assistant.
My lord, head assistant. From senior,
Head of
my lord, from
head assistant
post, my lord.
in the scale of pay page 51, huh? So and so, as admissible under ROP so and so with effect from date of his joining to the new post until further notice. Have you joined?
Yes, my lord. And I have the next page, my lord, 52.
Long time back.
Yes,
The
my
order
lord.
was of 1 year, 2 years back.
Yes, my lord, because the other side is not coming, my lord. Number of times I am trying to get it listed. He is not appearing, my lord.
Mr.
Ultimately,
The next para. Mr. So and so,
Take it
learned
from the-
counsel for the, huh?
take it up the
A.K. Talukdar, learned counsel for the petitioner, referring to the above said, above permission order dated 28/03/2023, submits that although the petitioner has been promoted, comma, the use of word temporarily promoted within question, is not creates a problem. It would create a problem as the petitioner appears to have been promoted not on permanent, rather on temporary basis. Mr. B. Chaudhary, learned standing counsel PWD, submits that the impugn order, the promotion order dated 28/03/2023 is a regular promotion in accordance with the rules and act. Therefore, there is nothing wrong in the above order. And if at all, if the petitioner is aggrieved, this that same would be a press cause of action, which may approach, which the petitioner may avail and approach the remedy that would be available under the law. Next paragraph. Having considered that, having considered the submissions of learned counsel for the petitioners, of the parties, and also perusal of the pleadings, as well as the office order dated 28/03/2023, comma. This court is of the view that the grievance raised in the present proceedings has been redressed long back on 28/03/2023. List of having regarding head to the submission that the impugn order, the office order dated 28/03/2023 issued by the executive engineer PWD, promoting the petitioner to the post of head assistant with the entitled scale of pay as per the ROP 2017 on the recommendation of the selection committee is clearly a misconceived one. Mr. As the misconceived one is clearly misconceived, is found to be totally misconceived as the above order of promotion, which is a regular promotion.
my lord, kindly have a look, my lord, kindly have a look.
If the
In a similar case,
petitioner is still not satisfied, he may avail the remedy as may be available under the law. In view of the above, the writ petition
my lord,
virtually become an infectious, therefore
my lord, my prayer was for
same is
promotion of the head assistant, my lord.
dismissed as infectious. Whatever you want to do, do it.
My lord, I
That
prayed
is
for promotion of
totally
the head assistant. It
misconceived.
is not completed, my lord.
It's a regular promotion.
Not a regular, my lord. Kindly see
It's a
the,
regular. I'm telling you, sir.
my lord, I have annexed a similar document. Kindly have
It's
a look.
a regular promotion. Word may be different.
One increment is not been given till now, my lord.
Huh?
One increment is also not given because of this, my lord.
It's okay. I've disposed it of. You have a remedy against this order also.
That's true, your lordship, but again, my lord, for this small issue, I have again rejected, my lord.
You have to file an
And
appeal.
I have, my lord, my prayer is for
Take
the
this-
post,
take
to the
this
post,
to-
my lord,
take
not
this
for half of the.
You
bill,
file,
my
you file an appeal against this.
My lord, your lordship can do it, my lord.
It's all,
My lord, your
sir,
lordship.
it's all misconceived. It's
My
a regular promotion.
My lord, it is not, my lord, finally.
Lordship, his
given-
prayer in the petition was different. He has got another relief. Lordship, whatever
What difference?
grievance he has
What
got.
is the difference?
There is a prayer for promotion.
Yes,
Prayer
Lordship,
for-
whatever grievance
That
he
is
has, he
promoted.
can,
What is there?
yes, he can, if he has got any, he can approach the
That's why
authority.
I asked him whether the pay scale of,
No, my lord, one increment is lost, my lord. That is also my prayer in the affidavit, my lord. I have lost one increment for this, my lord.
Lordship, he cannot change the pair by an, in
My
the
lord,
main
there is
request by an
subsequent, my lord.
additional
There is
affidavit.
subsequent-
He has to approach the
2
authority.
years back.
Yes, my lord, I
We
was
are not
fighting.
stopping.
My
If
lord-
you are agreed by the promotion order, come back. We'll
Yes,
see.
my lord, I have mentioned many a times because the other party is not coming, my lord. He is not contesting. That's why I have to again issue notice again and again, my lord. And my prayer, my
You
lord,
were promoted 2 years back. You
My
could have brought this the promotion, the instruction 2 years back. You could have closed the matter
my lord,
2 years back.
my lord, I prayed for promotion to head assistant, my lord. This is my prayer, my lord. It is done, but I am temporarily because of I am
You were
losing one.
promoted before 2 years back, before this this court was, elevated.
My lord, correct, my lord. But for only for this small thing, can you go for another repetition, my lord?
Sir, this is a regular promotion. I'm telling you.
My lord, in the same petition,
I'm
I
not
have
supposed
annexed.
to-
My lord, I have in the.
Sir, I'm not supposed to tell you, but
My lord, obliged to your
for
lordship.
your understanding,
Ob-
this is a regular
my lord,
promotion,
my lord,
nothing else.
Oblige your lordship, my lord. But in the same petition, I have to
Thank
annex
you.
that similarly confirm, my lord.
Thank you.
Temporary confirm, temporary confirm. I have annexed, my lord.
Yes.
May it please your lordship. Lordship, the steps have been completed with trustee service.
Hmm.
Trustee affidavit has also been filed and has been marked as flag C, orange flag C, my lord.
So service complete.
Yes, my lord. Flag C, my lord, may kindly produce flag C.
This is the affidavit,
Yes,
acknowledgement.
yes, my lord, that's stated.
Okay. MS so-and-so, MS so-and-so learned consecutive petition. The petitioner has filed an affidavit to show that the affidavit in respect of proof of service of notice upon respondent number 5, which is taken on record. Mr. Accordingly, the service in respect of respondent number 5 is complete. This for admission in after 3 weeks. Yes, next.
Well, did a leave application, my lord.
For what?
For filing review petition.
Huh?
For filing review petition. Here, my lord, the petitioner filed this application, my lord, seeking leave, my lord, to review the order dated 29th of May 2024. Percent WBC number 2741 passed by disposed of by this court. Here, whatever my lord, the writ petitioner, my lord, filed this writ petition seeking family pension and retirement benefit of a deceased husband, my lord. Now, the deceased husband of the writ petitioner, he had total 3 wives.
Where is that order? You have not annexed it.
In IM, with the IM, my lord, I have not annexed, but in with the review petition, I have annexed, my lord. If the record
Any
is there,
objection?
Well, there is another IA for there is a section 5 limitation petition. There is a delay of 226 days. Withdraw. Yes, withdrawing.
earlier, my lord, actually, I also filed another IA seeking, my lord, condemnation, my lord, but the registry, my lord, informed me that condemnation is not required. So ultimately, I was, my lord, asked to withdraw the condemnation application. And instead of the condemnation application, my lord, I was asked to, my lord, file the leave application, my lord. Since I was not a party in the writ petition, so, my lord, and I'm seeking a review of the order that was passed in the writ petition. So, my lord, I've been asked to, my lord, file.
So what is to be done? Hello?
I have no difficulty, madam. He may be multiple.
Heard Mr. So-and-so learned counsel for the petitioner. And also heard Mr. Yes, London Standing Council,
BTC, my lord.
BTC.
BTC, my lord.
And and you have no objection, any objection? Yes. Next paragraph. This is an application seeking leave to file a review. Leave to file review petition, review application against the order dated 29/05/2024, passed in WPC number 2741. Next one, having considered the ground set for and considering that the petitioner was not a party
In the writ petition.
in the connected writ petition in the prayer movement and as well as the prayer seeking leave to file review is not objected to by learned counsel for the respondents, I deem it appropriate lawful. I deem it appropriate. I deem it appropriate to allow this application accordingly. Leave granted. Next one. The petitioner. Leave granted. The IA stands.
And they want
Allowed in this point.
Lordship, we have to direct the registry to number the review petition. Now, Lordship, we have to direct the registry to number the review petition.
In view of the order passed, so and so, in so and so, IA, registry to number the IA,
Review petition.
and list accordingly. List accordingly.
Okay.
Lordship, this IA is for amendment of the writ petition, Lordship. Kindly peruse order dated 30/10/2024 of the writ petition, Lordship.
Amendment.
Lordship, kindly peruse the order dated 30/10/2024 of the writ petition, Lordship. Writ petition, Lordship.
Writ petition.
Writ petition order.
Court has directed
Lordship.
some other day, will dispose of some other day. Any objection?
No, Lordship.
Huh?
No. Actually, what has happened, Lordship? The case is for compassion and appointment.
Monday.
Monday, Lordship.
As agreed to the land council for the party list this matter on Monday.
Lordship.
24. IA. 24 IA will consider.
Oblige, your Lordship.
Yes, it's for what? IA is for?
IA filed by the inspector of school, my lord. But I could not serve with a copy, my lord.
You could not, or they could
No,
not.
they did not serve me.
Without
You
serving a
could not,
copy,
or he did not serve.
otherwise without serving a copy, you cannot file, my lord, but still
Where
it's
you furnish?
No, I had filed. A copy did not.
Mr.
on
Sorry,
Monday, my lord.
Departmental Counsel for the
I
petition
filed my result.
submits that he has not received the copy of the IA interview of him. Mr. NJ Katina Learning Standing Council. Elementary,
Secondary, my lord.
secondary education. Submits that he has, the IA could not have been filed without serving a copy to the Learning Council for the petition. However, he is ready to furnish a copy.
I'll give today or tomorrow. On Monday, my lord.
During the course of the day. List.
My lord,
On Monday, my lord, I have
need some time to file my.
that
affidavit, my
that will be decided on next date of listing, my lord.
No,
But I
we'll grant him. Grant him better.
because my lord,
Unnecessarily, because that day he will seek time.
because
File
my
an
lord, that is why my lord, I'm saying on Monday, my
We'll
lord.
give him, you give, furnish the copy today, we'll grant him 1 week's time to.
There is some urgency, my lord, that is why I'm praying.
Let's say,
On that day, my lord may consider his prayer for,
same thing.
that is why, my lord, whether it is required or not, my lord, that consideration may be given on that day, my lord. Whether it is required or not, my lord,
In case of final
his
disposal,
objection is required or not, that objection, my
What
lord.
is the order, interim order?
Because interim order,
Status quo, my lord.
My lord, the SMDC of the school, my lord, school in question was dissolved. Against the order, my lord, he filed a writ petition. On that day, there is an order of status quo, my lord. Because of that, my lord, as on today, my lord, there is no SMDC in the school, my lord. And because of that, my lord, we cannot disburse the amount for midday meal scheme, my lord. And because of 31st of March, my lord.
Monday.
Obligation. I'll give a copy today only, my lord.
Have you got it? Order.
Yes, ma'am.
Properly written. Yes. Almost 1 year.
May I please, Lord?
Yes.
This is, my lord, die in harness case. And earlier, my lord, the petitioner approached before the Sonal Court. That is, my lord, writ petition number 1336, 2009. And thereafter also contempt proceeding was brought, my lord. Now, finally, my lord, the district level, my lord, DLC recommended my name as a third grade post. That is, my lord, page 54. Now, here, my lord, last portion, my lord, I read page 54 because time is very short. And this recommendation has not been followed by the state level.
And when it is rejected?
State level, my lord.
State level has rejected?
No. Appointment me
Yes, take
as
steps.
fourth grade, not third grade.
Huh?
DLC recommended as third grade, but SLC appointed me as fourth grade.
Appointed. You have been appointed.
Yeah, appointed.
What is the difference between third and fourth?
They cannot, then they cannot claim the post, lordship. They cannot claim the post. OM is very
That's why.
clear.
This is the case, my lord. And
It's okay.
And
It's
RTI
okay. Only it's a recommendation only. As a
recommend,
matter of right, you don't.
Yes.
You don't have choice.
recommend, my lord, recommend third grade.
Forget
And
it,
so far,
sir.
so far RTI reply is concerned, RTI reply is saying that a post is available.
It's all right.
Third grade post is
Even
available.
there may be, so maybe there may be available. Forget about it.
But
It doesn't give you a right to claim because it's a compassionate appointment, right?
Yes.
Thousands are in queue.
but so far
At least
recommended.
you got
but
some. You have appointed, got appointment on
That's
fourth.
right. But so far
grade.
recommendation is concerned, that has not followed.
Not
This is the
necessary.
case.
It's a recommendation, not mandatory.
And recommendation, my lord, clearly stated that in
Sir,
purpose.
better you withdraw. We'll dismiss. Please withdraw.
Let me, my lord, the instruction from the party.
Huh? Withdraw it. What's here? You don't have a right. See, recommendation, your basis of is a recommendation in third.
Otherwise, I know that there is no very.
You know better.
And
You are closing it.
so, any other thing, my lord, please, even though I need to consult with them.
You take instruction, not for hearing, for closing the matter.
Yes.
You just convince the, be happy. Thousands are there in the queue.
Any other.
You are not getting, at least you are lucky enough. Tell him,
Withdrawal.
withdraw. Not Mr. So-and-so, consent for the petition.
With consultation of the due consult of the consent of the party.
Is it? Mr. So-and-so, learned consent for the petition. You are withdrawing.
Yes, Lord.
Submits that he has an instruction to withdraw this writ petition. As the petitioner, as the claim of the petitioner has been, he is to the post of grade 3 in terms of the recommendation of the district scrutiny committee.
DLC, my lord.
District
Yes,
level.
District level committee.
District level
committee.
for
And accordingly
appointment on
appointed.
compassionate ground of the state level selection committee.
State level committee.
State level
SLC.
committee has recommended
As
and
fourth grade.
in the post of grade 4.
Accordingly
On which the petitioner has already been appointed
and join.
and joined. Mr. Soin, Jackie Goswami, Lami Consul.
I appear for respondent number 2.
Record only. Considering the submissions and also consider that the petitioner have been appointed on in the grade 4 post.
Grade 4.
on consistent appointment
And he's still working.
Huh?
And he's still working.
and has joined in the post. The prayer for withdrawal of the writ petition is accepted. Mr. Accordingly, writ petition was on withdrawal.
I do.
It's better, sir.
Thank you.